Our panels over the course of this conference will talk about changes they anticipate in the coming administration. And I'm more convinced than ever that as immigration advocates, we will only achieve any of our goals through collaboration, community, and solidarity. And so I'm so grateful that you've all chosen to be here with us, engaging on these issues today. Before we begin, I'd like to thank a few people who made this possible. Sandra Tennessee, Associate Dean of Alumni and Community Relations. I think you all have met her on the way in. Christina Van Arsdell, Director of Continuing Legal Education. Samantha Martin, Director of Special Events. Also, the UHLC Information Technology and Audiovisual Departments, and the team at Facilities. Also, I'd like to thank the staff of the Immigration Clinic, Vanessa Lopez, Leticia Leal, and Rehan Ali Mohammed, who's with us over Zoom, and the administrative staff of the clinical programs, Thelma Baines and Rosie Martinez. I'd also like to thank Dean Leonard Baines, who can't be with us today, but for being so supportive of immigration law at the Law Center. I'd also like to give a shout out and draw your attention to the student volunteers who've been helping today. They are all very passionate about immigration and are interested in talking with you about being an immigration practitioner. Finally, I want to turn to the reason we're all here and the reason we get to do this. Joseph Vail. I never had an opportunity to meet him, so I'm going to pass the mic to Wafa Abdin to give a short tribute to him.
Good afternoon. It's amazing to be back here in this beautiful building. It is hard to believe that it has been almost 16 years since the passing of this very special man, Professor Joe Vail. After a distinguished career as an immigration attorney, an immigration judge, and a law professor, he started his career as a volunteer with AmeriCorps Vista, assisting attorneys in the landmark Supreme Court case that established the right of undocumented children to attend school. During the 3 decades that Joe Vail spent providing legal assistance to vulnerable immigrants, issuing legal opinions that underscored his unwavering commitment to the principles of justice and equality for all, teaching and mentoring young attorneys. And he had received several awards during all these years, including the State Bar of Texas Award for the free legal services he provided to indigent clients, the American Bar Association Lawyers, ALA, Elmer Fried Excellence in Teaching Award, the National Lawyers Guild Award, and was posthumously awarded the National Immigration Project Carole King Award. I met Joe in 1999 when he founded the University of Houston Immigration Clinic. You know, here we are. I was one of the first group of students who joined the clinic and were mentored by Joe. Since the clinic was new, we spent time doing intakes so we can get asylum cases, but he wanted us to really experience the full, experience of representing somebody doing the merits hearing during that semester. So he collaborated with ProBar, the South Texas Pro Bono Asylum Representation Program, to assign cases for the students. So we all had 2 weeks to, prepare the case, and then we were supposed to go to Harlingen to, be at the merits hearing and represent the clients. Sadly for me, my husband had a massive heart attack at that time, and he had to undergo 6 bypass surgeries. So I wasn't at the clinic these 2 weeks. I was with him and with my 2 kids, Zaina and Saleh. So when I came back to the clinic, it was the day before they were supposed to travel to Harlingen. I was very disappointed, of course, that I was not going to be there. And Joe, like always, he had this ability to sense how you feel, even without explaining. So he asked me, would you like to go? And I said, well, I haven't made arrangements, tickets, all kinds of things. He said, I'll take care of it. I said, I don't know if I can finish my case and prepare. He said, no, I believe you can. Let's go. So here we are. We went to Harlingen, and I had, I think, a day or 2 to prepare for my case. So, there, it was like a whirlwind of a week. I mean, doing research, representing the client. I did not win the case. My client was not granted asylum. I was disappointed, but I knew I did my best. And it was all due to Joe's encouragement and support and believing in me honestly. But that week really changed the trajectory of my life moving forward. I knew what I wanted to do. I wanted to be an attorney representing asylum seekers and doing it for the rest of my life. So I mean, it was really very special. So moving forward, I was off when I graduated that year. It was my last year at law school. I was offered a job as a staff attorney at Catholic Charities. And I thought, okay, I mean, I don't have enough experience. I clerked for a few months, but I can do it. I'll learn along the way. Well, it turned out Catholic Charities had only me as an attorney, and there were so many complicated cases that I needed to make decisions on. I had no clue. Of course, who did I call? Joe. So again, Joe said, you can do it, Wafa. I believe in you. I honestly did not believe him. I knew I couldn't do it, but I knew he was one call away. So, in 2 months, I became the supervising attorney. In a year, the legal director, and then in a few years, the vice president for immigration and refugee services. And he was part of my journey the whole time. So together we worked on so many projects that helped the community. I mean, a crime victim program, a Know Your Rights presentation. We both submitted our first funding to represent unaccompanied minors to the government. And this has really served thousands and thousands of young people throughout the years and continues to this day. So, it's, again, whenever I think of him, it's hard to believe that I would be where I am without him. Joe's dedication, considerable intellect, and talent developed the immigration clinic into one of the largest in the nation. Many of the graduating students of the clinic served as legal directors, supervising attorneys, and staff attorneys at different nonprofit organizations and pro bono organizations. Many of them excelled and became private practitioners who we all know in town. And some joined the government and also were serving the community. Joe was an extraordinary human being who impacted my life and the lives of everyone who knew him. He was so generous with his time, and he shared his knowledge freely and made everyone who interacted with him feel very special. Everybody thought that they were his best friends. Everyone he interacted with, really. His decency, integrity, and compassion inspired his students and made them better attorneys and better human beings. He was a kind and gentle soul who cared about those less fortunate and gave them a voice. He was a natural mentor who lived his life by example and left a legacy that will continue to impact future generations. Joe, I will always remember, appreciate, and cherish you as a colleague, a professor, and a mentor, but mostly as my best friend. Your spirit will continue to guide us, comfort us, and inspire us in your absence. Thank you for listening.
And now I'd like to turn it over to our first panel. Thank you.
Thank you, Anna. Good afternoon. My name is Zenobia Lai. I am the Executive Director of Houston Immigration Legal Services Collaborative. I have the pleasure of convening these immigrant justice warrior on this panel. So I don't know if this is the worst or is it the best stuff, but immigration world is pretty nasty right now. So the first panel, we're looking in, taking the law into its own hand, and how Texas foray into the immigration law policy and enforcement. And with me as speakers are Cesar Espinosa, Executive Director of Vail, Amruta Jundo, the founder and Executive Director of Lone Star Defender's Office, and Kristen Eder with Texas Immigration Law Council. So I'll start with Amruta, trying to kind of give a chronological picture of this Texas aggressive foray into immigration enforcement, starting with Lone Star operation. I'm sure there are other immigration enforcement attempts before, but the aggressiveness is probably started with Lone Star operation. I'll turn it over to you, Amrita.
Thank you so much. Let's see, I'll be pointing at the right thing. All right, there we are. Okay, good afternoon, everyone. Keep my phone out here to try to stay on time. So I'm going to speak to everyone this afternoon about Operation Lone Star. I'd like to start just by getting a show of hands of who here has heard of Operation Lone Star. Okay, about half the room, a little bit more than half. Operation Lone Star, which we're going to spend the next 15 minutes or so discussing, is one of Texas's biggest funded programs out of any kind of program that exists in the state. And as you will hear, it is going to serve as a blueprint for the Trump administration. And Kristen's going to spend a lot of time talking about that. So what I'd like to spend the next portion of my time doing is giving you a pretty thorough overview of what Operation Lone Star is, what we saw, so that you can understand both what we're currently fighting at the Texas-Mexico border, and so that you can become aware of things that we might see continue on a federal level. Operation Lone Star, which I'll call OLS, began in the spring of 2021 when Governor Abbott announced this operation. He, of course, also announced it on Twitter. And essentially, the operation started through the issuance of a disaster declaration. The border is being invaded. It's a disaster. We need to respond with the military. That was the rhetoric that we heard coming out of the governor's office. Interestingly, you can see in the tweet on the left, the justification for the operation was that it was to curb the movement of drugs and people, so human trafficking and drug trafficking. And as you'll see through the course of my presentation, that's not actually what was happening on the ground in terms of who was being arrested. This is a really expensive operation, as I alluded to in the beginning. It's a $10 billion operation. So that there is a ton of money that has been redirected from other programs and other areas of the state just into immigration enforcement at the border. But essentially what OLS is as the state's attempt to do what the federal government is tasked to do, which is immigration enforcement. So let me tell you a little bit about what I do and what my office's role is. As you all know, under the Constitution, if someone is arrested at the border, they're guaranteed the right to counsel if they can't afford one. So when Governor Abbott announced Operation Lone Star in the spring of 2021, that summer, the legislature acknowledged the fact that most of these arrests were going to occur in small rural counties that don't have large criminal defense bars. So they allocated funding for the criminal defense representation piece of the criminal cases that they knew would occur from OLS. And that's where my office steps in. My office is responsible for appointing counsel and taking cases that arise from OLS. So we have authority to do that through an order from the Supreme Court, and we provide representation to clients in 10 different counties. What are folks arrested under OLS charged with? Well, there are basically two charges that we see 90% of the cases fall under. The first is misdemeanor trespass. That is the majority of cases. So unlike what we saw on Twitter where it was supposed to curb human trafficking and drug trafficking, the reality is most of this $10 billion has gone towards prosecuting trespassing. The elements of trespass are there on the screen. We also see felony cases, predominantly the cases are for human smuggling, which is essentially the transportation of people from one location to the other with the intent to conceal them from law enforcement. You can see on the slide here that the majority of our clients are from Mexico. It's about 40%. However, a very large number of clients from that we represent from OLS are US citizens. And that's because about 75% of the people prosecuted for smuggling are US citizens. Starting in the summer of 2023, we saw a really large spike in our clients coming from South America. And so we see that Venezuela is about 9% of our clients, and that's because of the spike from the summer of 2023. This just gives you a sense in a 3-year period from the summer of 2021 to the summer of 2024, how many people were arrested under OLS. 15,000 people. And again, as you can see, and I will continue to emphasize anytime I talk about Operation Lone Star, 76% of the cases were for trespassing. So when we hear fentanyls coming across the border, Operation Lone Star is being used to stop people bringing dangerous drugs into our community, that's not played out. That doesn't play out with the data. The data is that 76% of the people are trespassing. And as you can see in here on the slide, most of the folks charged with trespassing, which is a misdemeanor, they get a time-served plea offer. So they get arrested and pretty quickly they're given a plea offer that if they accept, they would get out of jail immediately. And our felony clients typically get an offer for deferred adjudication, which is basically probation if they have no prior criminal history. All right, I'm going to talk to you about the system that was set up in Operation Lone Star, and it is a system that is absolutely separate and unequal, even though the criminal justice system as a whole is incredibly flawed. We saw most of these flaws in sort of heightened in Operation Lone Star. It's really quite shocking what we've seen over the past few years. This is a photograph of a magistration court hearing. Outside, under a tree, people lined up, men in white jumpsuits lined up, with the person on the right being a magistrate judge advising them of their rights. This is not what anyone should expect from our state, from any government, from a county, when it comes to a court hearing. But this is what was happening. This was early into the program. The state began this program arresting thousands of people with no courtroom spaces, no adequate facilities for people to be housed. And so the result was having hearings, court hearings that looked like this, occurring in parking lots in counties in West Texas. You've seen a lot of these images in the news, I'm sure, the concertina wire, the buoys, the very dangerous, life-threatening techniques that the state has employed to try to, quote unquote, deter people crossing, but of course we know that many people have been severely injured because of these tactics. And these are some excerpts from probable cause statements that were used to justify the arrest of individuals that we represent. The first top statement is from a trespass case, and it's, again, early in the program in 2021. And you can see that state law enforcement goes to an area, meets with federal law enforcement, Border Patrol, so they're collaborating together. And state law enforcement notes in his report that a Border Patrol agent was standing near the fence line with 2 civilians armed with long rifles and 2 illegal aliens lying prone with their hands on their heads. So you have essentially militia members, civilians with guns that are taking their sort of own initiative to hold undocumented immigrants at gunpoint on different properties, and you're having state and law enforcement just watch. We're also seeing discriminatory traffic stops. This was a car that was stopped because the window tint was suspected of being too dark, and upon closer examination, state law enforcement determined the window tint was legal. But as he spoke to the driver, he, quote, smelled an odor that was emitting from inside the vehicle. And he says that that odor is associated with human smuggling. Quote, undocumented aliens emitted distinct odor due to sweat and being exposed to the environment. So we see very racist tactics and statements being used to justify arrest. After our clients are arrested, they're transported to 2 large tent facilities that have been set up specifically for Operation Lone Star, where they have their first court hearing, their magistration hearing via Zoom. The average bail for a trespass client is $3,000. The average bail for a felony client is $85,000. They aren't held in local county jails because there's no space in local county jails. So Texas has set up an internal transportation system to take people from the border to 3 different jails that are located in 3 different counties, hours away from where our clients are arrested. And they're held in terrible conditions. These are prison units, post-conviction prison units that have been converted into pretrial detention facilities just for OLS clients. Court for misdemeanor cases occurs on Zoom. Critically for this group, nobody is ever street released in Operation Lone Star if they are a non-citizen, whether ICE has a detainer on them or not. If ICE has a detainer on them, then ICE will come to these prisons and pick up our clients. But if ICE doesn't have a detainer, rather than street releasing them, the jails have colluded and made arrangements with local Border Patrol where they will drive our clients who are non-citizens to the local Border Patrol office for processing. In the beginning of OLS, that meant that a lot of our clients were being expelled under Title 42. Currently, we see a lot of these clients being removed through expedited removals. So even if ICE chooses not to issue a detainer, our clients are not allowed to walk out of the jail. They always end up going to Border Patrol if they're not US citizens. Lots of bond forfeitures. We've seen in Kinney County, one of the biggest counties where OLS occurs, over $1 to $2 million in revenue that the county has made from Operation Lone Star. Just want to quickly mention, as you can imagine, client representation in a realm like this is very challenging. Not only are our visits occurring via Zoom because the clients are spread out in jails across the state, but we also have clients who, when they post bond, get deported back to their home countries. That's part of the reason why we see bond forfeitures, is because the client post bond gets deported to Honduras, attends court via Zoom from their home in Honduras, and has no ability to come back to the United States, let alone to Kinney County, Texas for their trial. But our clients, as a result, are in remote locations from their attorneys, from the courts, and so it can make representation extra difficult. I want to highlight some of the things the defense program is doing, because despite how difficult Operation Lone Star is, I was just commenting the other day, it truly feels like a Sisyphean task to like represent these clients, because anytime we get a win, it feels like, you know, the win is pulled back either by the CCA or a different court of appeals. And so we keep fighting, but we're going to celebrate the wins that we have gotten, but also share some of this with you all to hopefully inspire creative litigation in whatever areas that you're working on, the importance of continuing to fight even when the odds are against you. So the first challenge that we raised is an equal protection challenge. In 2021 and 2022, DPS was only arresting men for trespassing. They weren't arresting women. Again, what happens when you roll out these massive plans that aren't well thought out? You make critical sort of planning errors. And the planning error DPS made was that they only arranged for facilities that could house men. Now, it sounds like a very kind of, it's not a very sexy argument to say that, you know, women should be arrested too, but the fundamental, that's what we had to do as defense attorneys, right? We're representing the men, and we have to bring up the, you know, challenge, raise the challenges that apply to our clients' cases. But the truth is that you had thousands of men being arrested and being detained, and others similarly doing the exact same thing who were just being referred to Border Patrol. And so the trauma that our clients were experiencing going through this process, when another client who happened to be a woman didn't have to, or another person who happened to be a woman didn't have to go through the process, kind of emphasized the importance of us bringing this issue to light. And ultimately, a lot of the county judges who we never would have expected to agree with us agreed with us. And we had hundreds of cases dismissed. The Fourth Court of Appeals agreed with us that there was an equal protection issue. We won there. But unfortunately, the Court of Criminal Appeals did not agree with us. And we were reversed there recently, but we've now filed a cert petition to the US Supreme Court. We'll see if this is a case that they take up. But just kind of gives you a sense that you have to litigate every issue when you're dealing with unprecedented times like this. We're also litigating an issue about our clients' inability to get to trial. As I mentioned, our clients post bond. A lot of them get released in the United States, but a lot of them get deported to their home countries. And if they are factually innocent, they have no ability to come back, or if they want to go to trial for whatever reason, they have no ability to come back into the US for their hearing. At that point, they usually get bond forfeiture. And so we're litigating the injustice of that, because they should be able to have their day in court. I also wanted to tell you about the circumstances of arrest for trespass cases. And what we're really seeing is National Guard luring asylum seekers onto private property. So basically what we hear from clients all of the time is that they can't get an appointment through CBP-1. They get desperate because North Mexico near the border is dangerous. So they decide to cross over the river. They see National Guard, they think it's immigration. They're like, great, you know, after spending a long time on foot, journeying from their home countries, they want to surrender to immigration. They're not trying to sneak into the country. But National Guard will say, oh, if you want to turn yourself into immigration, walk this way and you'll see a break in the fence. And they follow those instructions only to then be led to an arrest site for DPS where they get arrested for trespassing. This is just a typical story of what we see, a case study in a trespass case, but shows you, really highlights the challenges of these cases. We had a client from Honduras who was arrested in Maverick County. She followed DPS's instructions. The trooper told her, come here. She came there. She got arrested for trespassing. She posted bond. She was released by ICE into the United States, relocated with family in the East Coast, but then had no financial ability to get to Eagle Pass, Texas for her trial. She was so traumatized by the conditions of these prison units that she was housed in before she posted bond that she said, you know what, I'm just gonna plead guilty. Even though she was innocent, even though she only entered because DPS told her to, she pled guilty. On the smuggling cases, one of the main challenges that we're raising is related to preemption, that the enforcement of smuggling of persons is something that the federal government should be doing, not the state government. And we recently had a victory by the 13th Court of Appeals, who agreed that the smuggling statute, the Texas smuggling statute, is unconstitutional. Unfortunately, just yesterday, the court decided to take that decision en banc and vacated the win, so we're keeping our fingers crossed, but that's one of the main challenges we're making there. The Texas human smuggling statute also criminalizes a thought crime. It criminalizes intending to conceal someone, but not actually concealing them. So in most of our cases, when people think of human smuggling, they think of people being hidden in trunks or secret compartments. That's not the reality of who's being arrested for human smuggling. The people being arrested are literally driving people who end up being undocumented. So you'll have 3 people sitting in the passenger seat, just like an Uber ride, and the driver will get arrested for human smuggling. Here's a typical case study here. I just want to highlight, because I'm running out of time, that in February of 2024, the state passed a new law that heightened the penalties for human smuggling to a 10-year mandatory minimum, which is insane, particularly crazy given that most of our clients are under the age of 30. About 15% of them are teenagers, and they're looking at 10 years for driving someone in their back seat who happens to be undocumented. But it also shows the disconnect between the legislature and the local communities, because we went to trial in a case recently with an individual who was arrested before the mandatory minimum went into effect. And the jury of that local community in Maverick County sentenced our client to 4 years. So we see a real disconnect between what the communities on the ground believe is justice versus what the legislature has imposed. And with that, I will turn it over to Kristen.
Thank you. Good afternoon. So now that you all know a little bit more about Operation Lone Star, we're going to talk about how Texas has really set the stage for a mass deportation campaign using Operation Lone Star and using Texas as the model. So I want to talk first, and as Amrutha mentioned, it was the spring of 2021 when Governor Abbott issued a disaster declaration. That issuance of a disaster has freed up financial and personnel resources to surge to the border in a way that was the governor was able to operate in a very quick manner. Similarly, we see President Trump talk about wanting to declare an emergency at the federal level. And it's essentially a way for the executive to make a power grab when it comes to immigration enforcement and not have to involve the other branches of government. So as Amrutha mentioned, that's kind of the general timeline that we've seen in Operation Lone Star, and it is going to be a prototype for an executive power grab under President Trump. The second, so there's really 7 key components of OLS that will form the basis of this mass deportation campaign. So the second is, as Amrutha mentioned, these mass roundups using state police officers, National Guard, and also the use of private contractors. So what we have seen in Operation Lone Star, as Amrutha mentioned, law enforcement works side by side, federal immigration enforcement officers, to direct people to certain locations solely to be arrested in this sham system of Operation Lone Star prosecutions. And they do it by using also this very wide network of private contractors. So the busing operation that Amrutha talked about uses and relies on private contractors. The detention centers, these temporary detention centers that Amrutha talked about, staffed by private contractors. So it forms a model of how state law enforcement, military, private contractors can work side by side to enforce immigration law. And so we anticipate that will be the second way the Trump administration will use Texas as a prototype. The third is this creation of separate, substandard, unequal system of justice that lacks due process and coerces guilty pleas and deportations of people that are legally and factually innocent of the charges and that have valid and good affirmative defenses to deportation. What they've done is they've repurposed those prison units that Amrutha talked about put people in very harsh conditions of confinement with very little opportunity to be released, but for the guilty plea to time served, but for agreeing to be deported. And so that is really borne out in the numbers. There have been, about 13,000 criminal trespass prosecutions since the beginning of Operation Lone Star. Only one of those 13,000 has actually had a trial. One of 13,000. That person had to wait 8 months in prison for his trial on a low Class B misdemeanor offense. So it just shows that people that are put in harsh conditions with no opportunity to get out will plead guilty, will accept a deportation, even though those people have valid defenses. And we know that the Heritage Foundation has put that number 40 as one of their hallmark ways to revamp the immigration system. They want immigration due process to be limited. So we know they're going to take Texas's model that they have set up and Texas's very intimate understanding of the psyche of people that are put in desperate conditions, separated from their families, and how it will be very easy to convince people to go back to their home country. The fourth is the Abbott busing program. As most of you have probably heard, during Operation Lone Star, another component was the governor busing people, setting up stations. So this was when I went to Eagle Pass, I visited a shelter. National Guard had set up a travel agency in the shelter, the migrant shelter. This is where people would pick which sanctuary, quote unquote, sanctuary city they wanted to go to. And our governor would use taxpayers' money to bus people to those places. In fact, we had many clients tell us that that's actually why they crossed through Texas, is because they wanted the free bus ride to New York or Denver or Chicago, wherever they were going. So Texas has utilized a very good system of transportation and also private contractors to bus folks to other places in the country. They already have those buses. They already have the ways to transport folks. And there has been a lot of talk about Texas to begin just basically turning those buses around, going into blue states and cities, rounding people up, putting them on those buses and busing them back to Texas to put in mass deportation camps that they have said they're going to build in South Texas. The fifth component that they're likely to adopt is the furtherance of anti-immigrant legislation. So we saw Senate Bill 4 from the fourth special session in the fall of 2023, creating a whole separate system of criminal immigration violations, illegal entry, illegal re-entry, and failure to return to a foreign nation. What that law will do if it goes into effect, and by the way, it may go into effect if we see the Trump administration drop the litigation challenge to Senate Bill 4. But essentially it turns every single peace officer in Texas into a de facto ICE agent with the ability to detain and arrest somebody for illegal entry or re-entry all over the state, and every single judge into an immigration judge, both authorizing and requiring state judges to sign deportation orders for people to return back to Mexico, regardless of where they're actually from. So again, that has been currently put on hold due to litigation, but it's a potential that that might come into effect. We know lots of other states have adopted copycat legislation for Senate Bill 4 to go into effect in their states. And so we're likely to see kind of a ripple effect if that does end up going into effect in Texas. The sixth component is these roving patrols that essentially pull people over for baseless reasons, as Amrutha mentioned, window tint, driving in the wrong lane, not passing correctly, not going the speed limit, certain, very suspect allegations of transportation code violations, and then absolutely just arresting the person for driving an undocumented person. I don't know how else to say this, but Texas peace officers have have almost universally, especially in areas along the border, taken the position that a driver has an intent to conceal for purposes of human smuggling if the passenger is undocumented. And actually, I put the same PC as Amrutha did on the top, but there's this other one. This was a client of mine, the middle one. She was driving down the road. She gets pulled over because she was driving in the left lane and not passing vehicles in the right lane. Stop was initiated. They asked for her ID. Her passenger, who is sitting right next to her, they asked who it was. She said it was her cousin. They see grass stains on his clothing and assume he's undocumented and arrest her for human smuggling. So we know that 8 USC 1324, which is the federal analog, is equally as broad as the Texas human smuggling statute. And we've seen our incoming border czar, Tom Homan, threaten people that they are going to be prosecuted for harboring, transporting, concealing, using this very broad federal analog statute. Most recently, he said, when there was somebody from Chicago saying that they weren't going to be participating in the mass deportation campaign, he said, message received. Please review 18 USC 111 and also see 8 USC 1324, game on. 18 USC 111 is a very broad statute. It makes it a federal crime to forcibly assault, interfere, impede, resist, or oppose a federal law enforcement officer for doing his job. They have threatened that they're going to prosecute officials for both of those statutes if they don't actively participate in mass deportation campaign. The seventh component of Operation Lone Star that we've already seen come into play at the federal level, targeting of organizations and people that work with immigrants with baseless civil investigations and frivolous criminal accusations. We have seen since really 2022 in our state, the Office of Attorney General in Texas go after people and organizations that shelter, that work with, and as we'll hear more about from Cesar in a little bit, advocate for immigrants in our state. We have seen Tom Homan saying he's willing to jail people like the Denver mayor. He is willing to go and basically where federal laws are defined, he's referred to these as sanctuary strongholds. We'll get to it in a second. He's recently sent off over 249 target letters to officials all over the country, threatening them in the very same way that we see our Office of Attorney General threaten people that work with immigrants in our state. I'm going to touch, this is a little bit, I'm going to go through this really quickly, but I think it's important for us to kind of see the bigger picture of how these investigations in our state have come to be and how they're going to serve as a model for an incoming Trump administration. And I actually want to go back all the way to March of 2022. There was a day in March, it was March 6th, when the Texas bar initiated disciplinary proceedings against Ken Paxton for his frivolous election law lawsuit that he filed. That was on March 6th. Within hours, I'm sorry, May 6th, within hours on the same day, Ken Paxton sends a letter to the Texas Bar Foundation right there on the right, saying our office has recently received complaints concerning the activities of the Texas Bar Foundation because they are knowingly giving donations to entities that encourage, participate, and fund illegal immigration at the Texas-Mexico border. That came hours after this one on the left came out, which was Ken Paxton's official statement to the Texas Bar. I'll see you and the leftists that control you in court. I'll never let you bully me, my staff, or Texas I represent into backing down or going soft on defending the rule of law. So this came within hours. So this was back in May of 2022. A few months later, November 2022, 3 organizations that are receive money from the Texas Bar Foundation, American Gateways, Tahoe Justice Center, and Equal Justice Center received these letters from the Attorney General's office, essentially accusing them of using funds from the Texas Bar Foundation to fund illegal immigration in our state, requiring that they turn over documents, putting them on notice that they were aiding and abetting the invasion of illegal aliens. We then see the next month, Heritage Foundation, which is the author of Project 2025. We see the Heritage Foundation come out with a study that they had done. And this study was essentially them parking a car in Del Rio, and they alleged that they tracked cell phones, they geofenced cell phones of migrants that had entered in Del Rio, Texas. And they then mapped out in phase 4 that there were nearly 3,400 unique mobile devices that were tracked going to 433 of 435 congressional districts. The very next day after this Heritage Foundation study came out, it was all over Fox News. Texas NGOs are helping to transport migrants to nearly every U.S. congressional district. May of 2023, we see a Dear Colleague letter come from a Republican member of Congress that lists certain organizations that they're being accused of taking taxpayers' money to fund illegal immigration. And they cite to that footnote right there, number 1, cites back to the Heritage Foundation study, calling out the Annunciation House, Catholic Charities Rio Grande Valley, many of these organizations Texas-based. Well, then February of 2024, we all know, Annunciation House. So February 6th of 2024 is when Senate Bill 4 from the 3rd special session, which is the human smuggling statute that Amrutha talked about, the enhanced penalties, the 10-year mandatory minimum, that goes into effect in our state on February 6th. And it's confusing because there's 2 Senate Bill 4s, but I'm talking about the 3rd special session. The very next day, February 7th, the Attorney General's office sends investigators to the Annunciation House from Austin to El Paso and demands immediate entry, demands that they turn over all their documents of their people that they've been serving, and accuses them of human smuggling, running a stash house, and facilitating astonishing horrors. They've also gone on throughout the litigation to accuse all Texas NGOs that work with immigrants as, quote, silent partners in cartel trafficking operations. It was a direct quote from a recent filing in the Annunciation House case by the Attorney General. So we then see, so they continue to lose and lose and lose, they being the Attorney General's office. They lose every single case that they have filed that we're talking about. So they lost that case at the trial court level in El Paso. A few days after that, we see then they target 3 more organizations, Catholic Charities Rio Grande Valley, Team Brownsville, and Ángeles Sin Fronteras. They also make very similar accusations. And I will say that the Team Brownsville came out on April 15th is when there's this letter on the left. The Heritage Foundation has a oversight project. It's their investigative wing. They had sent people down to Matamoros to pretend like they were volunteers wanting to go work at the organization in Matamoros on the other side of Team Brownsville. And they said that they found this flyer, this one right here on the left, in a porta potty, and it was encouraging migrants to come to the United States to go vote for Joe Biden in the election. This was on April 15th. On April 16th, Marjorie Taylor Greene had this, within 12 hours, had that letter blown up at the Mayorkas impeachment hearing. And again, right after that, we then see Catholic Charities Rio Grande Valley be targeted, Team Brownsville be targeted. There was a woman that had spoken out against basically saying this was fabricated evidence, and she gave a statement to NPR, I believe, in New York Times, and then within days, she gets a letter from the Attorney General's office. Again, they lost those cases as well, Catholic Charities Rio Grande Valley, Team Brownsville. All of these cases are still ongoing at litigation, but the Attorney General's office consistently loses these cases. It's because, we'll talk about in a second, the statutes that they're using. Then we'll hear about from Cesar in a second. Vail Houston's targeted in July of 2024. September 2024, they then turn their attention to an organization, Las Americas, that provides legal representation to migrants, accusing them of fraud for their services related to the Cuba, Haiti, Nicaragua, Venezuela humanitarian parole program. So throughout all of these different investigations, These are all civil investigations that the Attorney General has opened into these organizations. Yet throughout the entirety of the civil pleadings, all of these allegations that they're alleging are essentially criminal allegations. That is because the Attorney General in Texas is a weak Attorney General that does not have the ability to independently prosecute criminal cases. They have to have a special invitation in order to prosecute and have not received that. It has to come from the local prosecuting authority. So instead, what we see is using the civil litigation process to make these types of allegations. And these are, I've taken out the allegations and I've categorized them, but these are what we're seeing almost universally throughout these cases. People that work with immigrants are being accused baselessly of aiding and abetting illegal entry, harboring, human smuggling, operating a stash house, tampering with a governmental record because there's an organization that does asylum clinics, and the allegation was they were counseling migrants to commit fraud, including fraud within the asylum application process. Financial allegations, making generalized allegations that they take money and that they don't, they take money from donors and are using it in an unauthorized way. They've made allegations of just basic theft and also penal code, violations of tampering with governmental records, fraudulent crime of financial statements. These are some of the allegations I'm going to let Cesar talk about, but that were made in the Vail Houston case for these baseless 501c3 allegations. And I just want to highlight some of the potential risks that we've seen, because many of the times as we've tracked these investigations, we'll see certain patterns and we've seen certain trends, but these are just various ways that we've seen the Attorney General show up at a place of business. Sometimes they show up at people's personal residences with investigators, with letters, with subpoenas. They've sent them via certified mail. We've seen a lot of undercover migrants or volunteers that are people trying to gain access and videotape people. Also being mentioned on social media or a podcast. We've seen many of the investigations happen within days of being mentioned on X or in a social media post. A couple days later, the Attorney General will send an investigative request. Also being mentioned in state and federal hearings. And then the most recent, those that reside in a location that received an America First legal target letter. So what I had mentioned is on December 23rd, 249 of these letters were sent across the country, none in Texas, but in Oregon and Vermont and Chicago and places in Georgia, California, to various officials, governors, mayors, chiefs of police, and they essentially have put them on notice that they've been identified as a sanctuary jurisdiction violating federal law. Such lawlessness subjects you and your subordinates to significant risk of criminal and civil liability. So again, using really the model that has been established in our state with our Attorney General to target those that either work with immigrants or that have said they're not going to cooperate in a mass deportation effort, saying your jurisdiction's sanctuary laws or policy make a mockery of American democracy and demonstrate a shocking disrespect for the rule of law. So these have gone out across the country. And I'm actually going to turn it over. I'm going to talk a little bit. We're going to save it towards the end when we do some more Q&As, but I wanted to turn it over to Cesar for his story.
Thank you so much. So I'll talk about a little bit about me, this big-headed kid, and then I'll talk about the anomaly that is Vail. And I mean that in a variety of ways. So I'm a first-generation immigrant from Mexico City, Mexico. My family brought me here when I was 5 years old. I lived here in Houston, and then except for an awkward year when I moved to Ohio, but we don't really talk about that. We came right back. It's too cold out there. And lived in Houston my entire life. I was very blessed and very very blessed to be able to be in GT program since I was little. And then I accidentally got into the Vanguard program at Jane Long Middle School. And then I got into a high school here named DeBakey High School for Health Professions, which at the time was #1 in HISD. When I graduated, I always knew I was undocumented. So there was no unlike some people that we've met throughout the years, for me, there was no gray area. I knew that I didn't have papers since I was probably like 7 or 8 years old. Um, and I often talk about the little black book that my parents used to keep on the dresser that they would tell us, if we ever not come home, these are the numbers that you should call to, with family members in Los Angeles or in Mexico City, et cetera, et cetera. So when I graduated from high school, that was probably my first roadblock because here I was at the premier high school in HISD. From day one, it was college, 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 and here I was at 18 years old, and I was ready to go to college. I got a 1599 on my SAT. Missed one math question. I'm still mad about that. And I got accepted into a bunch of Ivy Leagues, but at the time, I didn't have papers, and at the time, in way in the early 2000s, I, I talking about being undocumented was very taboo. It was just like, you don't talk about it. My mom would tell us, like, don't tell anybody because if the neighbor gets mad at us, they're gonna call ICE on us and they're gonna come get us and things like that. So when I told my counselor, she pretty much said, there's not too much we can do for you. We called around. We remember talking to one of the Ivy Leagues and that I really wanted to go to. And at the end, they said, we want you to come to our school, but we don't know if it's legal for you to come to our school and for us to help you. And so I ended up at HCC. Then I went to U of H, and this is where Fiel was actually born. Um, Fiel was a small club of immigrant students that all we wanted to do was to get other students to go to school. We wanted to provide opportunities for undocumented youth to be able to not only access higher ed, but to access the resources for higher ed. So I remember actually one of the first times, I was probably like 16 years old, and I came to U of H, and I actually turned around because I saw a cop, and I was like, no, I'm not gonna do that. Like, I might get arrested because I didn't have a license. My car was all beaten up. So I was like, nope, I'm gonna turn right back around. But at the end of the day, you overcome those fears, and we began what we thought was gonna be a small club of students who would cry together, laugh together, share resources. And we accidentally became the largest immigrant-led civil rights organization in the state of Texas. And I say accidentally because, when folks ask me what, like what blueprint did you have, or like what 5-year plan did you have? I was like, our plan was just to survive for the next 5 years. Our plan was just to be able to be here for the next 5 years. Our plan was to be able to provide students with the opportunities for the next 5 years, and to be able to get resources into people's hands to actually create real change. I'm happy to say that through our program, and the reason why I'm talking about it is because a lot of times people see us on TV. They say, you guys are always on the news and you're always, criticizing this and that. But in reality, Fiel is so much bigger than that. We have several programs that we run. We have an access to higher ed program, which we still, till today, we're still graduating kids from Harvard and Stanford and providing them full rides for them to be able to provide for their families. With the passage of DACA, we've been able to get a lot of people licensed in nursing and in the law, the field of law, and in different fields that prior to DACA we weren't able to do. And so we started small, but we eventually turned into an organization that responds to what the community needs. We also do housing here in the local Houston area, which is a big deal. We do a little bit of disaster recovery. I mean, I say that sarcastically because we've raised millions of dollars for people after hurricanes. We've turned it over to in unconventional ways to people without red tape, instead of having people, because you got to think about what our community has and doesn't have access to. So I'll give you an example. During Harvey, we were out with the Red Cross, and they would say, people can sign up for the $400 in their bank account, and then we'll direct deposit it, right? Majority of people that we were working with didn't have a bank account. Majority of people that we were working with didn't even have a car at the time to be able to go to Walmart to get that money transfer. So we would, hand people money on the streets, basically. Don't ask me how, because I won't go into it, because then it's dangerous. But we try to provide people the resources and try to meet them where they're at, so that we can better their lives. And so that's what we do. I won't go too much into this, but obviously, as you know, Houston is such a vibrant, such a large community full of immigrants. I often get asked by a lot of people, was it terrible, like being undocumented? And I say, absolutely, it was. I was undocumented for 33 years, and I'll go into that in a second. But it was, but I actually feel lucky that I landed in Houston, because instead of me being able to go out to the world, I feel like the world came to me. I just got back from Mexico 2 days ago, and the first thing that I eat whenever I come back from traveling abroad is pho, because I love Vietnamese food. And I'm like, if I had lived anywhere else in the world, maybe that wouldn't be one of my favorite foods in the world. So when we started, we didn't really have guidance. We didn't really have like a blueprint for what Vail was going to become, but we knew what we wanted to do. And what we wanted to do was to let people know who we are. Like I said, I've been here for 33 years. If any of y'all ever go into the practice of immigration law, you're gonna find out the wait times are very long. I do come from a mixed status family where I have relatives that are US citizens, but they couldn't petition for me for one thing or another, or they could, but I would have to have waited 20 plus years and then face a 2 to 10 year bar, because I was here undocumented after the age of 18. And that really wasn't something that, we tried a lot of ways. We probably talked to every single immigration attorney that you can think of here in Houston and other places. And it wasn't a viable plan for me and my family. In 2012, I was able to get DACA. The Deferred Action for Childhood Arrivals program, for those of you who are not familiar, was an opportunity for us to get work permits for 2 years at a time, as long as we went to fingerprints, told the government that we were doing a good job, that we were staying out of trouble, that we paid $635 every 2 years just to be able to be here and be promised that we weren't going to be deported. In 2020, in the middle of the pandemic, I met the love of my life, and we got married. And for 2 years, I would not adjust my status. Everybody's going to roll their eyes now, because I felt guilty that why was I going to be able to do that while other people didn't have the opportunity. Well, it wasn't until we have a little one, he's 6, and it wasn't until I had to explain to him that Papi could not travel with him abroad that I was like, you know what, I'm not gonna put my child through that same trauma that I had. We're not gonna have the little black book under their mattress saying these are the numbers to call. So in 2022, I was able to submit my adjustment of status, and May of this year, after 33 years of waiting, I finally got my green card. Thank you. And I was actually sharing the story earlier that I just came back like 2 days ago, first time as an LPR, and I was like, because I had gone 2 times out as on advance parole. And both times that I went out on advance parole, they like detained me for like 2 hours, and they looked at my paperwork, and then they were like really rude sometimes. And so like this time I was like, okay, I got my green card, my passport, green card, passport. I kept checking, and I go to the officer, and he's like, what documents do you have? And I'm like, I have my green card and my passport. And he's like, welcome back, sir. And I was like, that's it? Like, I was like, okay, cool, bye. So now I'm here. But anyway, so fast forward this year, after many of you who live in the Houston area know that we went through Hurricane Beryl. And during Hurricane Beryl, our office got obliterated. So we lost our roof, and Fiel pretty much got destroyed during the hurricane. And this is important because we had just moved into our new office, and on our first day of opening our new office, a process server comes and they serve us with a lawsuit from the Texas Attorney General's office, uh, claiming a bunch of things. And I had always joked with my wife that if I ever got sued, I was going to call three people. One of them was our attorneys first, then my mom, and then her, in that order. And I think it happened in that order. I can't even remember. But we called up our attorneys at MALDEF, and they really graciously, within minutes, said that they would help us figure out this lawsuit. So what the Attorney General is claiming, and the reason why this is a little bit different than other organizations or other people that have sued is because we were the first organization outside of the border area to be sued. And we, unlike the other organizations, we weren't sued for harboring, migrants or anything like that, but we were sued for what they're claiming to be, or what they're saying is violation of our 501c3 or of our speech. The other thing that makes it different is that instead of offering a remedy, they're asking for a quo warranto order, which basically would terminate us immediately. And I often get asked, we got asked publicly, we get asked in court if we had been ever given. I had never talked to the Attorney General's office. We had never talked to the Attorney General's office before, up until they served us with this lawsuit. And so it was surprising, it was shocking, it was interesting, and to me, it was a opportunity to once again show face and fight. And that's exactly what we're doing. So in August of last year, we went to Harris County Court, and a judge ruled in our favor, said that the lawsuit wasn't going to go forward. And unsurprisingly, the state attorney said that they were going to appeal the lawsuit. So what was it? What day is it today? Friday? Wednesday. We got put before the 15 Court of Appeals, the brand new business court, and they heard our case and they asked a lot of questions, which depending on which attorney you talk to is either a good thing or a bad thing. And now we are waiting to see what the 15 Court of Appeals says. The implications that this has had for us, though, is that it's really taken a lot of we're not a huge organization. We're a rather small organization that relies heavily on volunteers and interns and people power to keep going. And what this has done to us is taken a lot of that time away from what we should be doing to be able to defend ourselves from this lawsuit that has been put before us. So we are hoping that the 15 Court of Appeals will make the right decision, but unfortunately, we don't know how far the Texas AG is willing to go in order to try to silence us or keep us from continuing to help the community. One of the things that also concerns us is, we're a couple of days away from Inauguration Day, and before we had at least a protection to ask the federal government for help, and now we're kind of sitting ducks. So, when people ask me, like, what are we going to do next? I'm the worst person to ask that because I always want to fight. You can ask Alain. I always like to fight, and so we're gonna keep going, and in whatever capacity we have, We just have to stand up for our community. Our community needs us so much right now. And so right now is not the time for us to go away. And right now is the time to keep fighting. When I got invited to this, I actually I had a connection to Mr. Joe Vail. Mr. Joe Vail was actually kept one of my mentors from getting deported back in the 80s. And if my mentor had been deported, then I wouldn't have been able to be his mentee. And therefore, I wouldn't be able to be here today and in this capacity. So in the spirit of Jovel, we like to keep putting it forward. I mean, I've heard all the stories. I've heard many stories of the kind gentleman he was. And so in that spirit, we want to keep going and we want to keep giving back and we want to keep paying it forward for a lot of those people who are still suffering, whatever the case may be. And I always tell people, you know, we're gonna do whatever we can to continue to fight and educate. And that's what Fiel does: is we fight and educate to keep people and to help people make the best decisions. So. The shameless plug is to follow us on social media: Facebook, Twitter, Instagram, and soon to be banned TikTok. That didn't come out. But anyway, you can scan our QR code and give us a shout out.
Thank you, Cesar. So, of course, we are here because we want to figure out how we can fight in a couple of days for the next 4 years or however long it takes. But I just want to bring us back to a kind of sobering note. So you might have received like 50 emails a day from different advocacy group asking you to contact a Congress person about this Laken Riley Act that passed the House about 10 days ago. And this morning, Senate passed the cloture, 60 votes to whatever is the minority. And it's very likely that as we are here, Senate already passed the bill. And it will be passed back to the House next week because there is an amendment to broaden the number of criminal offenses that would lead to mandatory detention under this bill. So I want to, we've been fighting a lot against, aggressive state usurpation of the federal authority to enforce immigration law. So given the prospect of Laken Riley Act becoming law, what do you project would be the impact of this law on, the state authority to infringe on the federal authority of enforcing immigration law?
So thanks for that question, Zenobia, because it is a big concern. We've been monitoring the proposed legislation quite closely. I see the Laken Riley Act really being a federal extension of Operation Lone Star in a way to move people detained under a criminal system throughout the 50 states and funnel them directly into the immigration system. So in the same way that Operation Lone Star has misappropriated the criminal justice system just to funnel migrants into a sham system for prosecution to then be turned over to Border Patrol, Laken Riley would expand that across the country. And it expands, so the recent amendment, the Cornyn Amendment that I think was incorporated into legislation today, would essentially expand to include even people that are just accused, not convicted, of low-level offenses such as shoplifting, theft, and would place mandatory detention requirements. And so we're talking about people being racially profiled, not being able to have their day in court, funneled into the system in much the same way that Operation Lone Star has operated on a smaller scale, and the potential of that happening across our country. So I really see it as, again, Texas serving as the model for this on a smaller scale, being a prototype, and then a way to expand that and just a way to lay the groundwork for mass detention and mass deportation nationally, unfortunately.
I just want to add on to that. As an advocacy organization, we always tell people, if you're undocumented, you want to avoid all interaction with law enforcement as on the receiving end. Now, a collaborator or a witness or victim to a crime, yes. But it's a fine line that we draw, right? And it's a fine distinction that we have to make. These types of bills would hurt or continue to hurt that relationship, and would continue to put all of us in jeopardy. Because if in a city like Houston, where there's about 600,000 undocumented immigrants, 1 out of every 10 Houstonians is undocumented. If I get mugged and the person that witnessed me getting mugged doesn't have papers, I would like for them to come forward. And it's in my best interest and in everybody's best interest for them to come forward. On the other hand, unfortunately, and I'm going to try to be very real here, in Harris County, this is already happening. Harris County, even though we don't have a 287G program, an agreement with the federal government, if you land in county jail, it's very likely that you'll get an ICE detainer even for smaller crimes. And we have had so many clients, so many people who get turned over to ICE for minor offenses or maybe even found not guilty or get their case dismissed, but then they already have that ICE detainer and then they're subsequently deported. So we've seen I don't know if many of y'all know this, but we are the #1 deporter in the country here in Harris County. A lot of people used to say Maricopa County was, and they were. But after the sheriff went away, we became the #1 deporting county in the United States. So for Houston, it won't have such a huge implication, but we see that in other parts of the country, it may broaden the scope and it may land more people in immigration detention.
So given the kind of grim outlook, we still want to work and advocate for immigrants. So Cesar, I want to ask you the first question, right? Given the situation that we are in, how do you safeguard your organization and your clients' confidentiality? What expression is protected for immigrant rights organizations versus what would be considered lobbying or political speech, as Vail was being accused of? And how to assist clients within the U.S. without being accused of human smuggling?
So the answer is we don't know. And that's that's the decision that the courts have to make now. We have educated people all the time. And now the AG brings up this claim, and we don't know what we can say or how we can say it or what we can do. So, I mean, I think we're in really trying times right now, where we're going to have to define what we should and can do and what we can and should not do under the law. I mean, and in terms of what we intend to do with our clients, we have to let people know, and we have to give people as many tools as possible for them to be able to defend themselves and for us to be able to help defend them. And we're going to need all of y'all's help. There's a lot of people that say, well, I'm not an attorney. I can't do anything. Yeah, absolutely you can. I mean, you can help people by sharing with your neighbors, by sharing a lot of the information that we're putting out there, and help create that sense of community and help create that sense of trust too. I mean, we don't know how bad things are going to get. We hope that they don't get that bad, but we don't know how bad things are going to get. And we are going to need all hands on deck to be able to defend people and to let people know that there's community behind them.
Neighbors watching out for neighbors is a very important kind of fundamental mutual aid concept. So, Kristen, we talked about people who are in the United States. What about people who are outside of the United States planning to cross the border? And how do they, as helper, how would you protect yourself from being accused of human smuggling? And how do you represent clients in expedited proceedings in a competent way?
Ooh, those are so many questions, Sophia. Why'd you throw them all at me? Okay, so, I think it's a situation at this point where we're going to see not just a crackdown on what they've deemed illegal immigration, but also legal immigration. So I actually have a
big concern for folks. I was in some of the encampments in Reynosa a couple weeks ago, and I met with a lot of migrants who had been there for months and months, that had sold everything they owned in their home country. They had journeyed, and they were patiently waiting for their CBP-1 appointment. Women and children, you know, many of them had been there over 5 months waiting in these encampments. And I have a real concern that once CBP-1 goes away, which it's likely to go away next week, I don't know what they're going to do. They're not going to offer lawful pathways to come to the country. So many people, thousands, have been basically led to go to the Texas-Mexico border to wait for CBP-1 appointments. And so there are people I know that have appointments on January 20th, and they're going to try to get all the appointments in before, I think, noon. And then I don't know what happens to the rest of them. I don't know how I would advise. I think at this point, it's a situation where, just like Cesar said, we have to wait and see. There's been a lot of talk. There's also been a lot of secrecy about what they're planning. And I think at this point, we're preparing for the worst. I think it's just going to be a situation where we're going to have to wait and see. And in some places, you might be better off not coming here, depending on how the treatment of immigrants are going to roll out in different places around the country. So I'm going to turn it to Amrutha to talk about the smuggling, because again, I do think we're likely to see an expansion of smuggling, both just in Texas, but also nationally. And I think that that is a real concern with the advocates across the country have a concern about how a weaponized Department of Justice, for example, could be used, especially given some of these target letters that are essentially threatening prosecution.
Sorry about that. As far as the smuggling goes, we're expecting to see the state and federal government collaborate even more than they already are in the new administration. In places like Texas and places near the border in Texas, local law enforcement is very friendly with CBP. They're all from the same communities. A lot of them went to high school together. They, on a personal level, get along very, very well. But there were limitations placed by DHS, kind of from DC, with respect to how CBP worked with local law enforcement in Operation Lone Star. And we're expecting those kinds of DC originated directives to go away, and for the two entities to be encouraged to collaborate with each other even more. As far as like whether we're expecting to see changes in like the prosecutions as it relates to smuggling, as you saw in the presentation, lots of people are already being prosecuted for smuggling, and we highlighted this, but I can't underscore enough how much the origination of the case is usually a BS traffic stop. If you were in these counties in West Texas, I mean, personally, I've been pulled over, and the officer told me that I was speeding 4 miles per hour over the posted speed limit 1 foot before the speed limit changed to 5 miles faster than I was going. And it's just one of those things where in my, however many years of driving, like never have I ever been pulled over for going more than 4 miles per hour over the speed limit. Even if I was doing that, I don't agree that I was speeding. But what was clear is that the officer saw me driving, and from the front saw, before I moved to Texas, I was living in California. My car has the California dealer's license plate kind of outline. And so it was very clear. I could see we made eye contact. I saw him look down, then I saw him quickly, do a U-turn and pull me over. They are keeping an eye out for anybody that doesn't look like they are from their local community. And a lot of these communities are small and they all know each other, and you will get pulled over for not stopping all the way at a stop sign or for going 2 miles per hour over the speed limit. We see it all of the time in probable cause statements. And so I say that because you can imagine when local law enforcement is emboldened to collaborate with the feds and know that not only are they going to have the backing of Border Patrol if they call Border Patrol onto the scene, but that the federal government might just say, hey, state, you prosecute them and kind of give them free rein to use this 10-year mandatory minimum, that we would expect the arrests to increase. The other thing that we could expect to change is what happens to the passengers in the car. Because right now, for the most part, the passengers are turned over to Border Patrol for processing. And from there, we don't really know what happens to them, but chances are they get deported to their home countries. But it wouldn't be surprising under the new administration if the passengers are also prosecuted. You know, they could be prosecuted by the state for things like SB4, illegally entering the state of Texas. They could be prosecuted by the federal government for 1325 or 1326 illegal entry or reentry. So the result is that, you know, in the past, the passengers of these cars, especially by the federal government, have been treated as material witnesses, you know, witnesses to the offense that the driver committed. But it seems like now there could be approach that everyone is criminalized, which, you know, to Kristen's point, may result in you advising clients, you know, hey, if you get pulled over, even if you're not the one driving, you likely will get arrested and you could get prosecuted. And, you know, who knows what kinds of punishments the different prosecuting agencies will be recommending going forward.
Well, sounds like there needs to be a lot of collaboration across different legal disciplines, right? Immigration lawyers need to work closely with criminal defense bar, and on the ground, you know, we need to create communities among, you know, our neighbors so that we watch out for each other. We've been talking at you for a long time, so maybe we'll ask for some, if you have any questions to ask any of the, oh, over there.
Hello? Okay. Um, if we have clients who are in Segovia or whatever with the pending, in my case, smuggling charges, I guess I have two questions. One thing that I just think is odd is the charges are under seal, and I guess maybe that's normal. Oftentimes when I have clients with pending charges, I can see them, but when I call to ask, sorry, you know they're under seal. And then secondly, if we have clients that have, for example, a pending 589, I don't understand how removal proceedings will look for these individuals that are in Operation Lone Star, if you're seeing that. So if he ends up pleading, and then the other wrinkle of this is, like, let's say he does plead, does Texas want him to serve those 4 years in TDC and then be transferred, or just deport? Will he give them that option? Okay.
You can see from our furious nodding of heads, yes, absolutely. Texas will want him to serve a prison sentence and get deported, but will not just sort of forego the sentence for deportation. Let me address the first part of your question, and then maybe Kristen can address the 589 part. But as far as so as I mentioned, Segovia is one of the prisons that have been converted into an Operation Lone Star pretrial detention facility. It's located down in Edinburgh, Texas. And let me first say, absolutely what Zenobia said is accurate. The collaboration is more important than ever. So making sure immigration attorneys are talking to criminal defense attorneys. Criminal defense attorneys have access sometimes to immigration attorneys that specialize in Padilla advisals. But if you are, depending on where you're located in the state, you might not have access to that as easily, although there are some, you know, kind of statewide organizations like My Padilla that exist. A lot of times attorneys just don't know about them or don't use them for whatever reason. The collaboration is so key because a lot of times criminal defense attorneys are not keeping up with the latest when it comes to immigration law. I mean, this is sort of, as a criminal defense attorney, I've been doing the intersection between criminal and immigration work for 12 years now. And even I, I can't keep up. Like, it's just things have changed so much. So I want to first underscore the importance of collaborating, making sure you're talking to the criminal defense attorney, making sure you are chiming in on whatever plea offers your client is getting, and that they have kind of your blessing that the plea offer is not a CIMT, or it's not going to prevent them from applying for, whatever kind of relief they might be seeking before it's too late and the client has signed. So that's the first point. But as it relates to documents under seal, if it's a state criminal charge, one awful thing about these counties that is unsurprising is that these cases move incredibly slowly. And I've at least gotten the response that the charges are under seal or not visible, not because they're actually under seal the way that we think about them, because they're trying to protect the name of a co-defendant. Most of these cases don't have a co-defendant. It's just the one person on the indictment. Oftentimes they say that because they haven't even filed charges. And that's because if there isn't a filed indictment, then the county, the court, has no record of the person. The jail will say, we have no record, we can't give you the charges. But you're like, but my client is sitting in jail. Clearly, there should be something. And it's not uncommon for some of these smuggling cases to go years before they get indicted. And it's, again, really important that the criminal defense attorney is monitoring the status of whether the client is indicted or not, because if they're not indicted within 90 days, they should be released from custody. So I would encourage you, if you are in a situation like that where you can't get your hands on the charging document, you've tried calling the court, the clerk, you've tried talking to the jail, you've tried reaching the defense attorney. Sometimes, as immigration lawyers, I just got an email from one last week. I am a criminal defense attorney. I love my people, but sometimes attorneys make mistakes. Sometimes attorneys are overworked. Like, as the immigration attorney, I will sometimes tell folks who reach out to me, like, email the court. Say, hey, I'm the lawyer in an immigration case representing person A. I've talked to the clerk. They say they have no indictment. I've talked to the jail. They have no indictment. My client's been in custody for longer than 90 days. I believe they're entitled to release. I'd like to flag this for the judge. And the court coordinator at least might forward that email to the judge and might get the conversation going. So definitely critical to monitor that, because there are a lot of people that are sitting in jail past the time that they should with no valid charges filed.
Yeah, and as it relates to the I-589, I mean, plenty of our clients that were prosecuted under Operation Lone Star, a very high percentage of our clients were here to seek asylum. So federal law authorizes that they are able to come to the United States to request asylum. That's exactly what they were doing. And then they get arrested by the state of Texas for either trespass, or if they're driving a vehicle, for smuggling. And just to be clear, I mean, the state of Texas does not care. The state of Texas, I've had clients that have said, they've asked, DPS, I'm here, I want asylum, I'm fearful. And they'll be like, we don't care. They really could care less. And so the situation is, they go into state custody. Once they're done with their case, or once they're done serving their sentence, they all are then turned, as Amrutha mentioned, turned over to Border Patrol, turned over to ICE. And it's there that technically they're supposed to be allowed to then say that they feel fearful of return, they want to request asylum. Sometimes those requests are honored and they're able to then either be released or transferred into immigration custody. Not always. Sometimes they're returned to their home country. And I think it remains to be seen how that's going to be handled under a new administration. And I think we all need to be prepared, just as Amrutha was saying, that things have been, things in immigration world and immigration law change so rapidly. I think we should all be prepared for, starting next week. I don't even know if there's going to be immigration law anymore. So I think we have to be ready to just be on top of the speed to which things are going to be changing, the speed to which executive orders are going to be issued. And, there are a lot of great organizations that have been preparing for this for months, that are prepared to litigate, prepared to organize, prepared. We've been doing a lot of community presentations, preparing communities to understand what their rights are. And so I think now more than ever, this profession is going to be so crucial in terms of working with people, making sure we get accurate, up-to-date information into the hands of people that really need it and that are going to be at risk.
I just had two things to add to that. Number one, and on the immigration detention side, and I've been hearing it come up and up again, a lot of people, just a couple of months ago, I don't know if it was a month ago or a couple of weeks ago, the Texas General Land Office offered space for there to be more detention. So we know things are coming, and people are like, well, that's unheard of. That's never going to happen. And I encourage people, for those of you who don't know, to remember that there was concentration camps in the United States during and right after World War II. So it can happen, and it looks like it could happen under this new administration. The other thing too is I hear us talking about these things. We have to talk more about them. Oftentimes, we need to get some of these folks who are in some of these really tough cases or unjust cases, we need to get their stories out. So that we know the real truth of the things that are happening. I also often ask people, what imagery do you see when we talk about immigration? And 99% of the time you see people with the tattoos on the face crossing the border and things like that, when even here in Houston, we have one of the largest immigrant-led medical centers in the world. And we don't talk about that. So we have to we have to reclaim that narrative. We have to reclaim the word immigrant for it to mean the real beautiful addition that it is to countries, not what we've been told otherwise.
I think that's an awesome way to end this panel. We are on time. So what is important for us to all remember is plan, don't panic. Things are going to get bad, but we all know what we are doing. And if you encounter someone that are caught up in, Operation Lone Star type of, arrest, detention, make sure you document the person's stories, because that may be, a plaintiff in a class action that would help us, chip away this egregious, immigration dragnet that is coming our way. Thank you so much.
Thank you so much to our panels. That was eye-opening, and a bunch of other adjectives I probably shouldn't list right now. Our next panel is focused on the border, and so I'd like to invite our panelists to come forward. We do have a panelist appearing over Zoom for us.
Thank you. I'll start over. Good afternoon. We're going to get started with our next panel, and it's entitled Turning Away the Huddle Masses, Closing the Border and Forbidding Access to the Asylum Seekers. And our panelists are Corey Hash, which is here, and Taylor Levy, which is going to be joining us on Zoom. Corey Hash is a senior staff attorney at ILRC, the Immigrant Legal Resource Center, where she provides training and technical assistance to immigration advocates throughout the country. She is also on the ALA National Asylum Refugee Committee. She previously worked at a boutique law firm in Austin, has been the managing attorney of Human Rights First in Washington, D.C., where she provided pro bono legal service representation and assisted pro bono attorneys and human rights staff with their cases. And she also adjuncted at the University of Kentucky College of Law. Our next panelist is Taylor Levy. She's an immigration attorney focused on border and asylum cases, provides mentoring, education, and advocacy to fellow attorneys and organizations, represented asylum seekers in numerous detention facilities, including Artesia Family Center, critical role in reunifying and played a critical role in reunifying separated families during the zero tolerance policy, and also provided support to asylum seekers affected by Remain in Mexico in Title 42. Taylor provides private consultation also to attorneys that need tailored guidance in challenging cases. And I will turn over the microphone to Taylor.
All right. Hi. Thanks so much for having me. That's funny. Taylor provides tailored guidance. So that's true. So lots of times what I joke around about is that I like to just obsess over everything I possibly can about the border and about asylum processing at the border to try and collaborate and see if we can gain intel and collaborate so we can all be more effective attorneys. So I would say it's a lot to have this conference on the Friday before the shifted administration. I think that a lot of us are probably feeling a lot of anxiety over Monday, or at least I am. And I get a lot of questions about like what's going to happen at the border, what's going to happen at the border, is asylum's going to be dead? And the truth is, in a lot of ways, asylum is already dead at the border and has been just continuously chipped away at by the Biden administration in ways that have really, really shocked me. I don't ever say this in the press because I don't think it's like effective for the movement, so to speak, but truly, honestly, things are worse for an asylum seeker at the border now than they ever were under Trump. Like they have, I feel that way quite strongly. And it's like, I never thought the kidnappings could get worse. And here we are, they're worse than they were before. And etc. So for example, like when you hear me saying something like that, you're like, yeah, but family separation, like we weren't doing that. You know, we're not doing that. That's the worst of the worst. And yet we are, right? So there is there was a lawsuit called Miss L where they officially ended family separation. And when I say family separation, I'm not even talking about, a more colloquial definition of a family where we're talking about aunts and uncles and children who are 18. I worked on one case where they waited for their CBP-1 appointment. They waited over 6 months, and their 17-year-old child turned 18 7 days before that CBP-1 appointment. So he's an adult man. So his younger siblings and his mom and his dad, they were all released as a family unit, and he was sent to a detention center. So that's not even the kind of family separation I'm talking about. That's all legal, everyday family separation, right? Of husbands and wives and adult children, even though they're under 21, right? They're over 18, so they're adults allegedly. But what we're seeing right now is lots and lots of family separations of biological father and biological mother and their biological children. And so when I say lots and lots, it's not the scale of what we saw under Trump, but it still has been hundreds. I mean, there was a ProPublica article that was released, and we've been working on dozens since about April, May in general. Lots of the different nonprofits have. I'm working on around 25 right now. And these are family separations that are on the basis of national security. And that's all the government has to say. There's no explanation of what national security means. There's no details. There's no actual terrorist charge. There's nothing else. It's all confidential because it's national security. We're not going to tell you why. It's national security. And so like the youngest child that's been taken and transferred into Office of Refugee Resettlement Custody is a baby. That baby was like 1 year old, and she was covered in the ProPublica article, and that mother is still detained. And then I have a case from last week with a 2-year-old, right? So they waited, and those are people who waited for their CBP-1 appointments. And then for some reason are separated. Both of those cases were CBP1, I believe, and they were still separated for this alleged national security. So we're seeing that happening primarily to Russians, people from other post-Soviet Union countries, so Ukrainians, Russians, Tajiks, and then we're also seeing it happen to a lot of different Middle Easterners, people from different Middle Eastern countries, and then we're also seeing it happen to Venezuelans and Colombians for allegations of people allegedly being a security risk because allegedly we don't even know. We're guessing. Maybe it's FARC, maybe it's Tren de Agua. These are the allegations. And then there's no criminal records. Like the parents are telling us, we have no idea why this happened. I'm not a gang member. I don't know, or I'm not a secret spy. How do you prove you're not a terrorist? And so we're already seeing that. And I think we're going to see that increase just exponentially starting Monday. And part of that is because today as well, today's the effective date for the mandatory bars and CFI's rule. And that rule goes into effect where it says you cannot pass your credible fear interview if you have one of these mandatory bars allegedly, and you can't prove that you can overcome it, that you have a significant possibility of being able to overcome it. So how do you overcome a bar where an asylum officer is saying, it says in my notes here that you are a security risk. Prove to me why you're not a security risk. You're like, how is anybody going to prove that, right? Over a telephone also, because credible fear interviews are happening over a telephone, through an interpreter. And then the interpreters being used for credible fear interviews are not certified interpreters. They're not court interpreters. And for all of y'all who practice in the room, it's not like court interpreters are the best of the best you've ever seen in your life, but at least they're certified, they have degrees, they have to be literate in the language. They're using interpreters from Language Line Solutions and Lionbridge, and we when we're making these appeals on negatives, we'll pull job descriptions where the job descriptions will say no high school diploma required, no, you don't have to be literate in the language, no formal training required, etc. And they're making like $25 to $30 an hour for at-home call center jobs where they have all these metrics on them at the same time to be effective. If they're constantly getting detached from the call, if they're admitting to the asylum officer or whoever it is, no, I don't understand, then they're going to be getting in trouble with their bosses in terms of their metrics and their ability that they're actually able to translate. But what that means in actuality is we have, for example, there's lots of different varieties of Arabic. There's lots of different varieties of, French that's spoken in France or that's taught in American high schools versus the type of French that's spoken in different African countries. And so you have all of this pressure on the interpreter as well, who might not admit that they're not understanding and that the applicant, the person on the phone in the detention center also doesn't understand. And the reason why there's so much impunity is because credible fear interviews are not recorded. So they're all done without any digital recording. You can't get the audio, you can't get video or audio from these calls. And if y'all have seen what people colloquially call credible fear interview transcripts, people will colloquially call them transcripts. Everyone in the whole bar needs to stop calling them transcripts. They're not transcripts. They actually say in big bold letters, this is not a verbatim transcript. They're just notes, as in like the officer's typing notes. So those are things you can focus on with the judge because we're seeing all of these being used for credibility determinations. My point is the vast majority of people who are crossing the border right now, if they can't wait for a CBP1 appointment, because the wait is 8 months, roughly on average. I just got myself into a distraction loop, but CBP1 is a ridiculously long wait. It is technically a lottery for some slots and a wait for other slots. So theoretically speaking, I could sign up today and get an appointment tomorrow. Or I could be waiting this average of like 6 months, 8 months, etc. That's the higher end of it. I think the average is about 4 months. And then the longest are the 9 months type people. So if I can't wait and I choose to enter in another manner, I'm going to be in a situation where I have to affirmatively claim fear. So that's the shout test. So that went into effect in June 5th. And that has been one of the absolutely most devastating things to happen to asylum law at the border. Because we already know, anyone who's been practicing already knows that you'll get border documents from Border Patrol sworn statements that'll say, right, like, oh, a 2-year-old said he came here to work. It's like they're bullshit sometimes. But now the Border Patrol doesn't even have to make those statements anymore. They don't have to make those alleged sworn statements. They don't have to ask people affirmatively if they are afraid. So instead, it's the migrant themselves who's supposed to be like, I'm afraid, help me, I'm afraid. Or show even that they're crying is supposed to be enough. But what happens, what we're hearing from all of the migrants over and over again is they didn't let me talk. If I tried to talk, they would scream at me. They would tell me that asylum was over. There was no more asylum. The border is closed. Every time I tried to speak, they would yell at me. And so day after day after day, and the statistics show this, we're seeing just plane loads of people being flown back with expedited removal orders, not with Title 42 orders, which at least didn't have the bars on them, flown to Ecuador, flown to Colombia, flown to Guatemala, to Honduras, to El Salvador, and then people just being expeditiously removed to Mexico. Almost all of the Mexicans are not getting a chance to seek asylum, even if they were to get to this level of the CFI, because Border Patrol just keeps saying, there's no asylum, no, you don't get to, or they won't listen to them. And then in Mexico, we're also accepting Cubans and Venezuelans. Not we, but Mexicans are accepting Cubans and Venezuelans with expedited removal orders. So you'll hear calls from people who are like, I crossed because on December 18th, there was this rumor put out by all the smugglers that December 18th was National Migrant Day and that there was going to be a reprieve and people could seek asylum on the 18th only. Not true. Mass deportations instead. And so that's the baseline. That's like what we're already seeing right now. And if you are lucky enough to be able to convince someone that you are afraid and I need my credible fear interview, a lot of those Central Americans and Mexicans will be having their credible fear interviews while in Border Patrol custody. And so they're in Border Patrol custody and there's no right for an attorney to go in person to Border Patrol custody. They won't tell you which facility they're at for alleged security reasons. And attorneys are supposed to be able to talk to them on the phone and they're supposed to be able to email with the officers, but we see it being really, really hard to do that. If they're lucky enough to get a credible fear interview, then the new standard is going to apply to those interviews. And that is a brand new standard that they invented on June 5th called reasonable probability. And there's some of you in the room who might be like, that's not a brand new standard. I've heard of that. No, the old standard was reasonable possibility. And now they were like, let's make a really confusing term with a different P word and call it reasonable probability. So it's so frustrating to try and write briefs on all of this because there's significant possibility, reasonable possibility, and now new thing called reasonable probability, which is supposed to be a little bit higher than reasonable possibility, but not as high as more likely than not. So it's supposed to be like, 49% instead of 51%. But it's not like anyone actually understands how likely is it that you're gonna have horrible things happen to you again. Is this only 47% or is this 53? Like nobody actually knows that. I feel like when I was first learning asylum law, I was like, okay, everyone knows what a 51 is. I don't think anyone knows at this point. I don't think the judges know. I don't think the asylum officers know. And so when it comes to, in CBP custody, that's usually only going to be Mexicans and Central Americans. Anyone from other countries, if they are lucky enough to be able to express fear, they're getting moved to the ICE facilities. And I'm getting questions from everyone across the world. Oh my God, why aren't they paroling people anymore? Like, why aren't people getting out? Why aren't people getting out? And you got to understand that a lot of this has to do with kind of math of supply and demand. We have something around 44,000 ICE beds across the country, and we have the asylum ban from June 5th. So Biden, in my opinion, right, for like horrors and not respecting asylum seekers. But in terms of, do I want to reduce the number of people crossing the border? Successful. Good job. Fewer people are crossing the border because we're subjecting them to unimaginable horrors and lots of kidnapping. And more people are definitely crossing the border without getting caught, like undetected people, because I hear about them, because it's so impossible to come and to seek asylum. You just get sent back or whatever. So it just makes people cross and cross and cross and keep trying. But anyway, because way fewer people are crossing, and then on top of that, percentage-wise, the number of people of apprehensions, the number of crossings versus the number of people who actually get referred for a credible fear is tiny. There was just this new filing in the Flores settlement lawsuit where they did calculations that was literally less than 1%. And I didn't check those numbers to make sure they were correct. But per month, the number of people they apprehend versus the number of people who get referred for a credible fear interview is only around 1%. And so you could think, oh, theoretically, it's because they're giving everyone else notices to appear, but it's not. It's because they're just, giving people expedite removal orders without that chance to have the credible fear. So you end up in ICE and you're in a situation where there's way fewer people coming in. ICE has all this pressure to fill the beds. We are paying for those ICE detention center beds. We are paying for all of the contractors and staffers to run the facilities. And there's much higher rates of detention. Couple that with matter of MS and the fact that somebody who crosses the border has a positive credible fear interview cannot then get bond from an immigration judge. You're in a situation where there's no more immigration judge bonds for most people crossing the border. We have lots of judges now applying that to anyone who's a recent border arrival, not just folks who have an actual credible fear interview. And then you have ICE who's putting their foot down hard, who's saying, no, you're from a threat stream country, you're from a special interest country, you're from a terrorist country. Sometimes they'll say the quiet part out loud. And we're seeing very, very large denials of parole requests across the country. And we're going to keep seeing that. And we're seeing people being picked back up as well. People who maybe had previously been released getting picked up already, even before Monday, for things that we wouldn't have seen that. We've really seen that a lot since the election, even a little bit before, but since the election, more and more people getting picked up for the type of minor infractions in terms of like reporting or something like that, that normally back in the day wouldn't have gotten them to ICE detention. So I guess the weird silver lining, if you want to be very bitter about things, if Trump follows through on his, rounding them up, we're going to go catch all the people. There's only so many ICE beds. It takes a long time to actually build concentration camps. There's a lot of administrative oversight for a concentration camp building, unfortunately. I'm just being very sarcastic. Sorry. I can't hear the room too, so hopefully you don't all hate me. But I'm very tired. And because of that, the one silver lining is maybe we'll see recent arrivals who have been passing their credible fear interviews not be as much of the target of all the ire of you're never going to get parole, you're never going to get parole, you're never going to get released, because instead it's always just like this. It's like whack-a-mole. It's like jumping on a big balloon or something where you jump here and then. So right now we're really, really hurting all of the asylum seekers, and we're like, you're not going to get out, you're going to stay detained the whole time. And maybe if priorities shift and we are doing raids and we're trying to catch everyone who has absentia orders, let's say, then there's only so many ICE beds, and maybe we'll start seeing parole rates go up. And we've already heard bits and pieces of that, and we've already seen some of that, of every single time when we're gearing up for what we're scared is going to be like a surge. Like the word on the street among all the migrants was today's the last day to cross, that everybody's going to cross at midnight tonight. For whatever reason, I don't know why that's the word on the street instead of Monday, but we have to prepare for mass arrivals and so we have to empty beds. So maybe that'll help asylum seekers and obviously hurt everyone in the interior. But just sometimes people will think that, oh my gosh, what am I doing wrong? Why I can't get someone paroled? Why I can't get someone released? And lots of times the answer is not because you're a bad person or because you're doing it wrong. It's because we're in the situation where there's all these pressures to keep people detained to fill those beds. And just also the officers lie to you. Remember that, please. Like ICE officers, they lie, and the guards, they lie to the detainees themselves. They lie to you potentially, because there's a lot of you want to give people false hope. You want to try and maintain a certain level of calm, a certain level of optimism. So you'll tell people, oh, I'm denying your parole because your sponsor wasn't a citizen. That's not necessarily true. I would much prefer any time to have the sponsor be this is my sister, and look, I'm an asylum seeker, and I go to court, and I have a lawyer, and I have an EAD, and I go to all my courts, I haven't absconded, then hey, I have a US citizen sponsor who I just randomly found from a Facebook group and paid $500 to. And that's what we see, like ICE, but they'll lie to you, and there's all these rumors and there's all this pressure. So if you're doing this kind of work, super important to remember. And then so all of that. So let's say you don't do detained work and you're like, oh my gosh, that's all going on. You have to remember that all of your non-detained cases, every single one, if somebody came up through the southern border on or after May 11th, 2023, you have to be thinking about the circumvention of lawful pathways rule. It is your burden to show that it does not apply. And I know that sometimes judges don't bring it up. Sometimes OPLA doesn't bring it up, but that's not going to keep happening for one. And this includes that it's your burden if somebody came on CBP 1. It is still technically your burden to prove that they came on CBP 1. That's not always in the record. That's not always in the 213. And so to be proactively planning for these things. And so now everyone in your case management software, you should be able to plan for, okay, there should be a checkbox. Did they enter on or after May 11th, 2023? Or did I say 2021? 2023. Or did they enter after June 5th, 2024? Because June 5th, 2024 is the other bar, the circumvention of lawful pathways rule. And so we have both of those bars acting at the same time. Both are going to apply to all of your clients based strictly on those dates if they entered at the southern border. And the burden is on them to show that they are still theoretically eligible for asylum. And so to really, really, really pay attention. Oh, that's my timer. That I'm all out of time. I didn't know it was going to go off loud. But that's all the things to pay attention of when you're working on these cases. And what we're going to see next week, no one really knows. Trump has said over and over again he's going to get rid of CBP 1. That's awful. It's just going to help organized crime. But at the same time, the majority of immigrants who go to their appointments in Reynosa for CBP 1, they're getting kidnapped on the way and extorted about 10 grand each. Because it is, how dare you pass through my territory without paying the tax, right? The cartel tax for the right to go to your appointment. The appointments have become very cartel controlled in a lot of ways already. So it's very sad if they get rid of CBP 1. I'm the only person who thinks that they're not going to, maybe. I think that they might not because there's really rich data that the US government can collect by using that app with the location settings and the facial recognition, and people sign up for the app like from all over the world, literally, because you're allowed to register from anywhere. You just can't ask for an appointment till you're close to the border. So they're gathering intel and data on, ISPs and everything else all over the world. So I think CBP 1 will end, and then I think it'll be rebranded with a different name and a red color scheme, but will be the same app. So that is all my time. I think I'll pass it on to Corey. That was a lot all at once.
Thank you, Taylor. Corey?
I'm not sure if I can use my slides here. Let's see. So I'm going to take us a little further abreast from the southern border to talk about some of the changes we've seen to the asylum system under the Biden administration and before, and then talk about what we're expecting. So I'm with Taylor completely in that the asylum system has been under siege for years. This is not something that's going to start on Monday or Tuesday. We've been having attacks on our asylum system. It's at the point of almost near implosion, I think, today. And so I want to talk a little bit about what got us there. So Taylor's talked about the circumvention of lawful pathways, which started in 2023, the securing the border rule, which started in June of last year. There are a few other pieces or rules that the Biden administration enacted over the past few years that really have kind of helped gut the asylum system in some ways. In 2022, we had the asylum processing rule, also known as the asylum merits interview rule, which I'll talk about in a little bit. And then 2023, the creation of the Family Expedited Removal Management Program, or the FIRM program. And then just this last year, we saw the expansion of the expedited removal program to the northern border. And
It's gone again.
We saw the expedited removal program expanded to the northern border. So I feel like the theme today, if you want to take anything away, is really focusing on sort of the narrowing of asylum eligibility and the fast tracking of the asylum system are two key themes we see in all of these programs, and I think we're going to see under the Trump administration. And I really hope that all of you will take away today, and I'll come back to this in a moment, is the need to really understand expedited removal. So for years, expedited removal has been something that's happened at the southern border. If you practice in the interior, you're like, it's something that happens down there. We don't really need to think about it. And I think that's shifted, and it's going to shift big time starting next week. And so we saw just last year, the Biden administration expanded expedited removal to the northern border. So anyone coming over crossing over into the United States from Canada was being subjected to expedited removal as well. And for those of you who are not familiar, expedited removal is a fast track removal system that allows low-level Border Patrol and ICE officers to order someone deported in the moment without the right to challenge that order, without the right to a hearing or to see a judge, without the right to be, with some very limited circumstances, be released, and very little access to counsel. So the Border Patrol agent there on the street, you're deported, all done, and that's essentially what it is in a very brief summary. So this happened at the northern border, and we saw, extremely quick processing of asylum seekers at the northern border and the expansion of the Safe Third Country Agreement. So the Safe Third Country Agreement is an agreement the U.S. and Canada have to essentially avoid forum shopping for asylum between the two countries. If you land first in the United States, that is where you will seek asylum, and vice versa in Canada. So if someone comes to the United States from Canada, they will be returned to Canada, seek asylum there first. While there are some exceptions, the Biden administration limited the ability of asylum seekers to present evidence of those exceptions in the expedited removal process. Just talking a little bit about, is this, no. All right. Sorry, we'll keep talking. I just want to talk a little bit about the asylum merits interview, or the asylum processing rule that came into effect in 2022. And essentially what it did, it is allowed, the Department of Homeland Security decided to funnel certain asylum seekers into an interview process with USCIS. All right, it's working, here we go. And what it did is allow them to be released to travel to certain cities in the United States if they pass a credible fear interview, which Taylor talked about. And instead of going before an immigration judge and going through the removal proceeding process, their case would be adjudicated by an asylum officer. The idea behind this was really great, right? We would all prefer that asylum seekers have a non-adversarial interview with an asylum officer rather than a very adversarial proceeding in immigration court. However, it was a fast track system, right? People were given it was a very short turnaround until they had their interview, very little time to access counsel, very little time to prepare and obtain evidence from abroad. The AMI process has been halted, restarted. It is happening a little bit in certain cities, mainly to families in the FIRM program that I'll talk about. But again, the theme is fast track, limited access to evidence, limited access to counsel. And that's what we also saw in the FIRM program, which was announced in May 2023. And this was for families who were encountered typically at the southern border, who were planning to travel to certain cities in the US, and allowed them to be released and have their credible fear interview in Houston, in San Antonio, in, there are 45 cities where these interviews are being conducted. And so just allowed families to be released and to do this process in a non-detained setting. But again, it's been rifled with significant problems because it is an extremely fast-track process with limited ability to obtain and present evidence and very little opportunity to access counsel. These types of interviews, the asylum merits interview has not been happening in Houston. We aren't none of the cities in Texas have been identified for AMI, but firm interviews, these CFIs, are happening in Houston and in many cities in Texas. You know, if you're an attorney and you're practicing and you get someone who's like, I had a CFI and then I had a hearing and it all happened within like 20 days and the judge said no and I'm about to be deported. And you're like, 20 days? There's no way an immigration court case went that fast. It may be a firm case, right? They're happening so fast that by the time they call you, it's all done. All right. I do expect we're going to see, if not the same program, more of this happening under the new administration. I do want to spend a little bit of time talking about what I think has been a key issue with the asylum system, and that has been the growth of the asylum backlogs over the past 2 decades, but over the last 5 to 10 years in particular. So you can see, this is for USCIS data. I didn't prepare slides for EOIR for the immigration court system, but I'll talk about it in a little bit. So in 2023, USCIS hit the 1 million mark. That means that there are over 1 million affirmative asylum cases pending with US Citizenship and Immigration Services as of 2023. And as of today, there are over 1.4 million pending affirmative asylum cases. And this is a significant issue, and I think is where the implosion is going to happen, right? This is the root of part of the problems that we have, in my opinion. And so if you look at this one, and I just have to state really quickly, I'm not a mathematician, I'm not a data scientist, and I'm particularly bad at graphs. So I hope that this just illustrates to you that if you look at, it's supposed to be red, but it looks kind of blue on the bottom, right? That's the number of applications for asylum that are received by USCIS every year. So that big blue, does it look blue to y'all? Blue, right? Purple, gray? Okay, the big block, that's asylum filings to USCIS. That little orange block, that's how many interviews are completed each year. The green block, that's how many asylum cases are completed. It means a final decision is issued each year. And I mean, you can see there is the number of filings outpaces the number of case completions and the number of interviews conducted substantially, right? So again, with the caveat that I am not a mathematician, based on just my calculations, we are looking at a 35 to 50-year backlog for affirmative asylum cases if no new filings are received, right? And I did this based on, over the past 4 years, how many cases they've completed on average their most productive year. If they keep that pace, which they won't because they're all going to be focused on the border, right? Then maybe they can get through it in 13 years nationally, Houston, maybe a little bit longer. If their slowest year in the past 4 years, the number of cases they complete, nationally, it's going to take them 35, Houston 52, if no new applications are filed. This is just based on the backlog we have today, right? This is based on USCIS data. It's available on their website. You can just go and like geek out on the numbers if you ever want to. And this doesn't include the immigration court backlogs, right? So the immigration courts have a backlog of 1.5 million pending asylum cases, close to 4 million pending cases total. And that was as of like the end of September, the end of October. So you put that together, that's close to 3 million pending asylum cases. Don't ask me when you're going to get your asylum interview, I guess is the takeaway from this. I think it's unrealistic to expect that we're going to get through this backlog in my lifetime, right? Without pretty significant changes. This is the result, not of Trump, right? This is a result of decades of systemic neglect of the asylum system. And what I feel that asylum has become a political football in this gamemanship, this political gamemanship, and this is what has resulted. All right, so imagine no one else comes. We still have 3 million individuals and families waiting for their day to find out if they're gonna get permanent protection in the United States or not. So this is what we have going into Tuesday, right? So there we are. That's what we have right now. What can we expect? I think my colleagues in the earlier panel talked a lot about enforcement. And while this panel is not focused on enforcement, I think we cannot talk about access to asylum without talking about how mass enforcement is going to be a barrier to access to asylum in the future. So we've talked about increased criminal prosecutions if people are being funneled to Operation Lone Star, even to federal prosecution for illegal entry or reentry, and then to this credible fear process. It's going to make access to asylum much more difficult. We saw in Trump 1.0, the proposal, I think it actually happened and then didn't happen, the expansion of expedited removal outside of just the border into the interior. This is something we are expecting to happen right away or pretty close to it. It doesn't require a change in law. It's on the books. The agency just has to decide that's what it's going to do, right? So if I have any plug for all of you, it's get familiar with expedited removal, get familiar with reinstatement of removal, get familiar with the credible and reasonable fear system, because that may be what we're practicing in the coming years, all right? We've already talked about expanded detention. We know that in Texas, we have the groundwork for that to happen, but we also have sister states who have enormous immigration detention centers like Louisiana and Mississippi and Georgia. And so we can expect that even people living here or people coming to the US through Texas are going to be moved over to those areas where there is really limited access to counsel. I don't know how many immigration attorneys in Georgia are doing detained work. Maybe we should move there. It's extremely limited. And then last but not least, accelerated court dockets. So this is not anything new. Accelerated court dockets have been around for years. In the past, here in Houston, we had what was called the Family and Minors Accelerated Docket, the FAM docket years ago. We had one called the Recent Border Crossers. That was under Obama administration, I believe. And then lately we've had the Recent Arrivals, RA docket, which are just fast-tracked cases. And that means that they should be typically completed within 180 days, which ironically is statutorily how quickly all asylum applications should be adjudicated, but they haven't complied with that for at least about maybe 10 years, as we saw the backlogs. So these are some things we can really expect to happen in addition to everything else, but these are all going to impact asylum, right? We're going to see these coming through. Taylor also talked a little bit about some of the border issues that we can see coming through, but just to reiterate, we do expect a return of some of the policies and practices that we saw under Trump 1.0. Title 42, there's been a lot of talk about Title 42 returning. Some of you may have seen there was like a New York Times article about a week ago where hardliners in the future Trump administration are trying to find a public health disease to use as a basis to reenact Title 42. Which will result in pretty much all asylum seekers being rejected, expelled at the border before any chance to even access the credible fear, reasonable fear asylum system at all. The Remain in Mexico program, Taylor mentioned, we do expect that may come back. In fact, some people expect that may be coming Monday or Tuesday, that we may see that coming in soon, which if you were not around in Trump 1.0, essentially required everyone wanting to seek asylum to remain in Mexico, and then they would appear at the border and show up and attend a tent court hearing in Laredo or Harlingen or Brownsville maybe, but otherwise stayed in Mexico for the course of the removal proceedings. Asylum cooperative agreements, which were agreements with certain countries, which allowed us to just put asylum seekers on a plane to another country and ship them off, and then bar them from seeking asylum in the US. Trump Project 2025 and several of the materials have said that asylum cooperative agreements, they're hoping to enact several of those. And then just expanded bars to asylum, criminal bars to asylum, we already have lots of other bars with the circumvention of lawful pathways and securing the borders, but if you traveled through another country, if you didn't seek asylum, those types of things coming back in different ways, we are expecting them to return. Let's see. We've already mentioned we do expect CBP-1 to be ended, and then the related parole programs. So we do have several parole programs that the Biden administration enacted over the years, from family reunification parole, this Cuban, Haitian, Nicaraguan, Venezuelan parole, and other, the CAM parole, the Central American Minors parole, all these temporary parole programs, we're expecting those to be terminated pretty quickly. Those did allow people a way to come to the United States lawfully and then apply for asylum through the affirmative process. That may not, that's unlikely to continue pretty soon into the administration. And then sort of further on into the system, we are expecting unfavorable case law coming out to really restrict asylum in different ways, both through sort of procedural hurdles in the system, as well as narrowing the grounds for asylum that we saw in Trump 1.0, institution of an asylum application fee, which sounds so small with all these other things that we're talking about, but you know, creating financial barriers for individuals who seeking asylum, who in that first year here in the United States don't have access to you know, may not have the means to pay a significant fee to file for asylum. Restricting access to employment authorization. This happened in the first administration. We may see this happen again. Either eliminating completely employment authorization, the right to work for asylum seekers, or restricting it based on a further timeline, which is what happened in Trump 1.0. We had to wait longer before someone was eligible to apply for work authorization, or just setting up other barriers that really restrict when and how someone can get employment authorization, which is really critical to be able to support yourself while you're waiting for your asylum application to make its way through the 35 to 52 year backlog. And then this is one that I think we didn't have in Trump 1.0, but I think we all have to be really aware of, is the possibility of congressional action to limit access to asylum. You know, Project 2025, one of their key components is congressional action to remove the particular social group as a protected ground for asylum. It could go further than that. I know some advocates, some here in the room, just think 208, INA 208, which, you know, governs asylum, will just be completely eliminated. I'm hopeful that it won't come to that, but we are in a space in which, you know, Congress may act in this regards. And so that is where we are. Again, I think we don't exactly know what is going to sort of roll out in what way, but we know that the two themes are going to be the narrowing of eligibility, the fast tracking of cases to the point where it's really difficult for us to intervene in meaningful ways unless we relearn how to practice asylum law, which is my call to action for all of us, right? And then just putting up a lot of institutional and procedural barriers for people along the way. So I guess one of the questions that I was asked before I came here today was to say, what is it that we can do now? Again, I'm gonna ask you all to go home and learn about expedited removal and the credible and reasonable fear process, understand it, learn about reinstatement of removal, because as more and more people are removed and they're coming back, we need to understand what we can do or not do for them in that context. And then, you know, find connections, find community. I've been practicing immigration and asylum law for over 20 years, and I'm planning on Monday to not be on email. I am going to sit at home with my family and try to disconnect, because I know the next 4 years are going to be a slog, and I want to be there at the end of it, and I want all of you to, and all of your friends and families and colleagues to be there as well, and your clients. So find ways to set your professional limits and your personal limits so that you can get through this administration and be there for your clients in the years to come. As Taylor, I don't know if you sat there listening to Taylor and you're like, wow, gosh, she's talking about all this stuff happening. I didn't know that was happening down at the border. Just know that if you're going to jump into this, you have to be informed, right? Learn what it is that you're going to do. And if you don't know it, consult with someone like Taylor, take trainings. ILRC offers trainings around the country. Nonprofits in Texas receive free access to our trainings. And just, you know, set those professional limits. If you're not ready to jump into credible and reasonable fear interviews, there are other areas of immigration law and other areas, parts of the asylum system where you can be helpful. So I think I'm going to pause there. My time.
Thank you. Taylor, is there something you would like to add before we go to Q&A?
Yeah, how much more time is in the session? I forgot. Is it 3 minutes or is it 13 minutes? Or whatever.
Yes, you can have as many minutes as you want.
All the minutes, let's just do the whole day. No, I just want to really, really reiterate.
10 minutes for Q&A.
I want to super reiterate what Corey just said about, like, y'all, I'm obsessed with asylum, right? This is like my thing, asylum border. You do not have to do this work. You can set boundaries. You can say no. Don't take on a case like this of, oh my God, help me, help me, help me. My sister just crossed and she was detained 24 hours ago and da 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 da. Unless you're able to take on this ridiculous case in this ridiculous system that does everything possible to grind us down. Because what I didn't even say is that credible fear interviews happen 7 days a week, so Saturdays and Sundays, and federal holidays, and they won't pre-schedule them. So all you really can do is give a cell phone number and just wait around for the phone. I've answered these calls literally in the shower. And then the immigration court hearing. So if you lose your credible fear interview, which statistically there's the debate, but they're giving us bad stats. We got one number of, it's like, who knows? It's like around 43% passage rate, but I actually think it's even lower. I think they are counting the stats wrong in one area. But it's statistically, they're not going to pass their credible fear interview if they even were to get one. And they're not going to get one without intervention because allegedly they're not afraid. So if you hear a call, it is like an emergency, all hands on deck. So if you have a call center that's answering your phones or an assistant or a virtual assistant or whatever, and it's these recent arrivals, particularly from Mexico or Central America, it's not, I can schedule you for a consultation next Thursday, which is a totally reasonable way to run your business. That is a much better lifestyle. But just don't take on these types of cases. Give that kind of training to your staff, because otherwise it's an emergency, all hands on deck. This stuff, the court hearings happen 7 days a week also. And the court hearings, you cannot enter your E-28, you can't enter your appearance for the court hearings until they've been docketed. And they're very, very frequently docketed the night before, sometimes the morning of. So when they're 7 days a week, I'm talking like they'll be docketed Friday night for a 7 a.m. hearing on Saturday. And you can't enter your appearance until then. So you can't get access to the court record. And the passage rate for a negative credible fear review hearing in court is 20% or less. And so you need to be dropping everything to write a brief if you want a chance to have an actual chance of winning these. And so it's like, it is very, very stressful, awful work. And you can also choose to not do it. But doing it poorly, even well-meaning poorly, is problematic. And I'm always just, that's why I'm here to help people. I love helping people. But I get so sad by the attorneys who were well-meaning. They're not trying to hurt anyone. They're trying to help. But then they just kind of don't know what they're getting into. And you don't have to do this kind of work. You can do other kinds of work instead. And there's no shame in that. So I just wanted to add that to what Corey said, because I was like, yeah, that's a thing. My biggest hot tip I would say is everybody should read Matter of MAF and become really familiar with that, because that case says, it's old, it's from 2015. I had never heard of it till about a year ago. A subsequent asylum application is properly viewed as a new application if it presents a previously unraised basis for relief, or is blah, blah, blah. So if I was the Attorney General under Trump, probably the first thing I would do would be recertify this case and make it even more explicit that bare bones asylum applications don't count. All of these migrants who have filed bare bones asylum applications online with notarios, lots of times even with attorneys. I've filed bare bones asylum applications in my lives to preserve the deadline and preserve the claim. We are seeing Matter of MAF get invoked all across the country by OPLA already extensively. And I think we're going to see a lot more of that. So become really familiar with that case. You can fight back. There's ways to fight back against it, but be aware of that. And then the last thing I wanted to flag before we do questions is just don't run around like Chicken Little, but there are a lot of very reasonable minds who think that the way in which the expedited removal statute is written is, let's say I was apprehended at the border within 14 days and 100 miles, right? Because that's the current rule. And then DHS, in their infinite wisdom and unfettered discretion, chose to give me a notice to appear and then allow me to be on my merry way. That DHS, because my apprehension was within the first 14 days and 100 miles, they can later choose to once again exercise their unfettered discretion and choose later to put me into expedited removal. So we're talking interior. We're talking people who've already been released. We're talking people in Houston and in San Antonio who were released with notices to appear or released with 485s or whatever it is, potentially having those NTAs dismissed, or if they were in the case of NTAs that have never been filed and now being put into expedited removal, even if it's now been longer than 2 years, even if it's been 20 years, theoretically, if their original apprehension was within the parameters. So that's a little Chicken Little crazy, but there's a lot of people who think that way. And part of why we know is because we see how DHS interprets Lone Star a lot of the times. That, okay, you were in state custody for so long, but you were apprehended within the time. So it's worth thinking about and being conscious of.
Thank you. Would you like to add something, Corey?
This is not about policy, but I recently read like a statement by Paul Schmidt, who's a former immigration judge and former chair of the Board of Immigration Appeals. And he was talking about inherent in both the agency's understanding and the public's belief about asylum is this conflict between those who believe that, the Refugee Convention and our asylum law should be extended to give as many people protection as needed, right, to come here under our asylum laws. And then in the other extreme are those who believe that asylum is a loophole to our standing, to our existing immigration laws. And that in points throughout the history of, the immigration laws, we've sort of been in the balance between the two. We've leaned one way or the other. And we're at a moment in which I think the public at large, our government bureaucrats in our system, with some exception of some, good bureaucrats, we do have them, right? That in general, right now, the public believes asylum is a loophole, and that is why it is being shut down. I have faith that the system, this may be echoing what Kristen said earlier, that the system is going to become so bad that eventually the public sentiment will return to believe that our asylum laws are intended to be a refuge and we should be extending them in that way again. But right now, we're not there. Everyone believes asylum is a loophole. But I would say let's have faith that we're going to get to what I think were the inherent reason why the Refugee Convention was created and why asylum laws exist was to afford protection, right? And we'll get there again. We just got to stay in it for the long haul.
We'd like to open it up for questions from the audience, including those of you that are on Zoom. Please send in your questions. Yes?
Can you hear me if I shout?
Yes.
Okay.
Is it working?
There you
Oh,
go.
okay. For those of us that don't remember the Remain in Mexico, what's the difference between that and the CBP1 app?
Corey, do you want to go or do you want me to go? I can't see you. And now I can see you. Okay.
Signaling to you, Taylor.
So Remain in Mexico officially legally is called the Migrant Protection Protocols, which is a very 1984 name. So from like a comms perspective, everybody changed the name to Remain in Mexico because at one point it was originally called that and then they officially called it MPP. So if you've heard of it that way. But the big difference between Title 42 and CBP1, et cetera, is yes, the goal is to make the migrants remain in Mexico. But remain in Mexico officially, or migrant protection protocols, MPP, is you seek asylum either at a port of entry, and it could be CBP1, but you seek asylum or you enter irregularly iwi. You are given a notice to appear. You don't have a credible fear interview in the last iterations of migrant protection protocols. You just would be given a notice to appear, and then you are sent back to Mexico to await your court hearings. So to have all of your master calendars from Mexico and then eventually your individual calendar. So that would usually mean 3 months between each master, and then eventually an individual. And so you'd have to live in Mexico while you're waiting. So it's like a non-detained court proceedings, but you're in Mexico. And then you go to the bridge, every 3 months for your court or whatever. And so some ways it seems reasonable. Okay, wait your turn. But then the danger to migrants is just astronomical. And the most dangerous place for migrants to be is the bridges. That's where most of the kidnappings happen, especially when the migrants have to all show up at 4 a.m. in the dark to go to their court hearings. I used to go to the bridge every morning at 4 a.m. and hand out candy and answer questions and be a street lawyer in the dark from 4 to 10 in the morning. Once MPP ended because of Title 42, which went into effect in Title 42 during COVID, we're just going to deport everyone, but without removal orders. And so right now we're kind of in de facto T42 land because we're just alleging that people aren't saying they're afraid. Like, I have met a Palestinian in detention for 3 months in ICE detention who allegedly never told anyone that he was afraid. We didn't know he was afraid of return. 3 months, Palestinian. So obviously people are afraid.
Next question.
Hi, speaking of Palestinians, I represent a lot of Palestinians, by the way. And I wanted to ask you, what if any, is there that we can do to help people that just want to go back home? Like, for example, like you said, I have a situation similar to that, where he was represented by another attorney. Now his brother, he just says, I just want him home. I'll pay for everything. And he's still waiting. Detention already knows that. And he's still waiting for a flight to go back to his home. I don't know. I think it's Lebanon, if I'm not mistaken, or to Jordan. Is there a way that we can expedite it? Us as attorneys contact detention, this one in Harlingen, for example, and say, hey, there's a family member that's willing to pay for this. Can we get him home?
I mean, I would say that feels a little bit too specific. You're happy to reach out to me for a consult. I don't know if Corey has more to say about that, but in a nutshell, this is a huge problem right now with lots of the extra continentals, because we don't like people not from the continent. We very, very rarely allow extra continentals to voluntarily depart not under safeguards. And so, for example, there are loads and loads and loads of Russian citizens in detention post final order of removal who are just waiting to be one of the ones who can be deported, because they deport the Russians through United Arab Emirates. And the United Arab Emirates will only take so many people. There's only so many ICE guards to accompany them on these commercial planes. And so a lot of the different Middle Eastern countries and a lot of the different African countries are waiting at least 6 months for their removal. And that's even when they're begging for it. So yes, this is an issue. It's painful on purpose. We're hurting people on purpose, right? Sorry, Corey.
Yeah, I mean, this goes back to those of you who work in the removal defense space or who work in detained space understand that this is one of the frequent lies that is told. If you just sign your deportation, you won't have to wait the many months, weeks, whatever, for a hearing, for an interview, whatever it may be. And that's often not true. So to just remind people of that, it isn't always faster, right, to sign your own removal. But there are protections for people who are detained post-order. I mean, it will depend on the type of order of removal that they may have and where they're from, et cetera. But there is a process, the post-order custody review process, that they should be going through. There is a manual that provides information about that process. And so I would just reach out and just be checking this manual and ensuring that he's getting his post-order custody reviews happening every so often.
Next question.
Yes, question for Taylor. You mentioned at the beginning that some biological parents are being separated from the children. and then the children are placed in our custody, do those children then become unaccompanied alien children?
Yes, they're unaccompanied. That's why they're in our custody. They're considered unaccompanied separations. So they're supposed to be marked as separations.
Okay, thank you.
Do we have any questions from our online audience? There's a question over here.
Just wanted to ask if you foresee any changes on the access of unaccompanied children to asylum with USCIS.
I actually had this in my slides and it somehow slipped out. As we were just talking about this, it reminded me. I think to the contrary, we are expecting or fear that protections for unaccompanied children might be rolled back under the new administration. And that may be some repeal of the TVPRA or some other congressional action to limit it. And then there is concern about what's going to happen to, like, ultimately to the Flores settlement and how that will roll out. So I'm afraid that I don't have a good answer for you, and I'm actually worried to the contrary, that we might see rollbacks in those areas of protection. In the affirmative space, we do have the JOP settlement that's going into effect, and those protections should, continue for some time. But I'm sorry, I don't have any other hope.
Next question.
Seems naive, but seems pretty bleak, everything that's been said. As far as alternatives to asylum, have you looked at anything else? I mean, right now you're getting a 5-year work permit. You have TPS extended for several groups. Are you looking at employment or family cases or used teas? I mean, I'm just trying to think, if people are going to be battling and representing clients, what alternatives do they have besides asylum?
I mean, I'm going to say that everyone seeking any type of relief needs to be screening for backup forms of relief. And that's not just for asylum, whether you're looking at family-based immigration, whether you're looking at U's and T's. Many of these types of relief, there's risk that some of this can be rolled back as well. Asylum is not the only area of concern in the immigration system for certain. So I think if you're practicing, you need to just be looking everywhere. And your strategy with your client should be, here's plan A, B, C, D, because you've just got to have a deep bench of relief if it's available. I don't practice employment-based immigration, but I do think that is something that people really need to be considering, working with colleagues who are familiar in that area and making sure that isn't an avenue. We have the waivers increasing or the waivers for DACA holders that exist for now. But, I do think that is something, if you practice in the humanitarian or family areas of immigration, I'm not saying go out and learn employment-based immigration today, but make sure that you're not leaving that stone unturned as well, and turn to your colleagues for a referral for a consult to see if there are other avenues for them as well. But again, not just for asylum. I think for everybody going through the system, you really do need to be looking at backup relief.
Do we have any other questions?
Wait, can I say another thing? Do we have time? Real quick?
Do you have an online one? Oh,
Yeah, I can say something.
we'll go online and then we'll come back.
Sorry, give me a second. So if it's a client's burden to prove that the circumvention or legal pathways doesn't apply, what do you recommend they use to meet that burden?
So if they use CBP 1, if they use CBP 1, then they have to, they should have an email. They should have an email that they got a CBP 1 appointment. And they should probably be able to access that because people get pretty obsessed with CBP1. And to be able to access that email, usually they have screenshots as well that they sent to friends or family. Technically, they're supposed to be able to log into the app here in the United States if they still remember their login credentials and get it that way. I will say until about April of last year, majority of people using CBP1 were using it with the help of helpers, and helpers became very much organized crime in a lot of ways. So people maybe weren't using their own actual email addresses or their own accounts and don't know how to log in. And so they should have screenshots, etc. I will say the biggest thing that I see people mess up on is assuming that inherently because someone went to a port of entry because they're an arriving non-citizen, that they must have used CBP1, and that's not true. There were some other ways occasionally to get in through the ports. It's really, really hard now to ever get through the ports otherwise, but throughout the time that CBP1 has existed, there were sometimes other openings.
How do you see the Trump's administration position regarding the supremacy clause and the position of the states like Texas? How do you think that is going to play, if that's going to play a role, an important role, especially having in mind that there is litigation with the Biden's position in a completely different role against the states like Texas role?
I'm first going to say I'm not an expert in the supremacy clause, but I do think we know that the Trump administration is probably not going to necessarily aggressively protect federal authority in the ways that the prior administrations have done. And if I'm not mistaken, and I know some of you in the audience may be here, but I believe the Lake and Riley Act did expand state authority to challenge federal policies. So that is another area in which, without having to prove injury is the way that I understand it. And so that's another way of sort of, I think, carving out a little bit of the supremacy issue that we'll have to see how it's going to play out. And I think, and Kristen, I don't know if she spoke about this, but you know, in many ways, Texas is taking on these controversial issues to push the issue of supremacy and to push this issue of the confrontation of state and federal powers in immigration. And so we likely will see one of these cases end up at the Supreme Court and see whether, you know, we will have a different outcome than Arizona v. US and other challenges in the past. So I think yet to be seen. I don't know if Taylor, you want to add anything to that?
Do we have any other questions from the audience? If we don't have any questions from the audience, I'll ask one last one. Given that our clients are very comfortable using WhatsApp, and as attorneys, we've become comfortable using WhatsApp with them, and the relationship between the incoming administration and Meta, which owns WhatsApp, and knowing that WhatsApp collects data, what do you suggest, or do you have any concerns?
I think all of us who are practicing in Texas need to be really careful about digital security. I think Kristen and Cesar talked a little bit about some of the actions taken against nonprofits, but I think all of us should be looking at how we as attorneys, our firms, nonprofit organizations are communicating with clients, how we're keeping our digital files, and really do an audit of digital security, and that includes communication with clients. So I can't speak to WhatsApp particularly. I haven't used it significantly with clients, and I'm gonna actually turn it over to Taylor to talk about that, but I think we're in a moment in which we need to all be looking at our own digital security practices and our work with clients, just for the well-being of our clients, but also knowing that we have an aggressive attorney general in the state and an incoming administration who has been seeking to demonize immigration attorneys. So I'll just leave it at that. Taylor, do you have anything to add?
Yeah, I mean, I would say I probably have 1,000 plus former clients or former people I gave legal advice to in my personal cell phone from WhatsApp because terrible policies, right? And terrible personal policies of boundaries, etc. So I think people should be very careful about that. I would say for a quick tip, the number one tip I try and give people is don't take any calls or give any advice for someone outside the United States trying to seek asylum. I feel that way pretty strongly as an attorney who was doing this work extremely extensively in Mexico. And I believe everything I was doing was ethical, but I am being targeted, or I was targeted by the Trump administration. I am being invoked in all the targeting that Abbott is doing of my former employer, Annunciation House. And I think that it is incredibly hard to be educated and understanding of all the different nuances of the way the smuggling routes work and the way the different laws interact, et cetera, that just a really good and easy, firm practice is no, I will not advise you, person in Turkey, about how you can seek asylum in the United States. No, I will not advise you, person in Mexico, about how to seek asylum in the United States. That to have a boundary within your firm potentially to not do that advice either, unless you are very, very able to stay up to date and current and educated on how to give that advice ethically. And remembering that you're not licensed in Mexico, most likely, unless you are. And if you are, hi, we need more of you. We're dual licensed and we'll be able to advise on Mexican law. Let me know.
Thank you to our panelists. We'll turn it over to the next panel.
Thank you so much to our panelists. And now I'd like to invite our speakers and moderator for our final panel looking at Loper Bright and the future of asylum appeals or immigration appeals more generally.
Get this adjusted. Sorry, guys. You could use the break anyway. There's only so much of the parade of horrors you can tolerate. Okay. All right. Hello, everyone. Welcome to UH. Thank you so much for being here. I hope it's been a great conference. My name is Daniel Morales. I am the Dwight Olds Chair in Law here. I teach immigration law. I write about immigration theory, probably far afield from the stuff you do, to up in the clouds. But it's wonderful for me to be here and hear what's going on at the granular level. I've learned a lot just in the short time I've been here. So today we're going to talk about Loper Bright and its implications for immigration law. And to do that, we have not me, thankfully. We have Sheridan Green. Sheridan is an award-winning immigration attorney who Texas Magazine has called remarkably accomplished, with notable victories before some of the most powerful courts in the country. He convinced the U.S. Supreme Court to make the Fifth Circuit Court of Appeals review denials of untimely filed motions to reopen, convinced the Fifth Circuit that assault is not a crime involving moral turpitude, and convinced USCIS that professional wrestling benefits the nation. So I think he went to Brigham Young and South Texas College of Law, and he loves his job. And he is here to tell us about Loper Bright. So let's get started with that conversation. Thanks so much.
Thanks, Daniel. I would like to start out by saying that I'm sort of terrified at how much I've learned from the previous speakers. I had no idea how far behind I was on detained issues, and I don't know why that is, because I'm an AILA member and I try to keep up with stuff. It might be just not as much interaction with lawyers who do detained cases, and maybe fewer lawyers are doing detained cases. But I really learned a lot today that I did not know. This is going to be a little bit of a different tone and not nearly as dramatic, because we're talking about administrative law. I would like to get an idea of how many of you, if Jimmy Kimmel were to come up to you on the street and ask you to explain Chevron deference in a couple of sentences, I would like to, just by a raise of hands, to know if you would be comfortable with that. I'm just trying to gauge. Raise of hands. 1, 2, a couple. Okay. All right. So we've had this year a really big change in administrative law. For 40 years, the bedrock of U.S. administrative law has been a case called Chevron versus Natural Resources Defense Council. And this summer, the Supreme Court finally threw it out. And so this is really has far-reaching implications for everything that we do. It's not like, you know, a modified categorical approach case or like an asylum case or a crime involving moral turpitude case where it affects that one issue. It really affects everything. It affects asylum. It affects employment-based cases. It affects naturalization. It affects everything because it has to do with the way that the courts are reviewing the administrative decisions and everything that we deal with on a daily basis, unless you're, you know, also doing criminal or doing other things. Within the immigration sphere, what we deal with is all administrative law, and almost everything involves interpretation of statutes on the part of the agency. And to understand that, if you still have your statutes and regulations in book form, which probably a lot of you don't anymore, but I do, and you set your INA code next to your CFR, just your 8 CFR, and look at the difference in width of those books, you'll see that the statutory basis for our laws is very, very succinct compared to the regulations, which are very, very long. I was looking this morning just at the definition of an L visa. I think it's 3 lines in the Immigration Nationality Act, and in the CFR, I didn't count, but it's at least 10 pages. And all of those 10 pages are interpretations of that statute. So this question has to do with, are those interpretations valid? And the regulations are interpretations, and then of course the agencies also, you know, the BIA and USCIS will further interpret the statutes in the adjudications. So this, in short, this really impacts everything. And the other thing that I want to say before we get into it is, I feel like there are going to be, and there should be, a lot of questions about, well, what about this area of law? What about this? What happens with this particular question? You know, maybe it's an asylum question, or maybe it's something else. And for most of them, at least from me, the answer is going to be, that's a really good question. Now we have to go back and look at precedents that maybe you've never needed to look at for a very long time, and look and see how those things were resolved, to see if there's some vulnerability there to where issues could be relitigated now that the courts are supposed to put a little bit more effort into interpreting statutes than what they were doing before. So first of all, Chevron deference. So the idea of Chevron deference, it is a, let me just experiment with this for a minute. Okay. The idea of Chevron deference is the agency's interpretation, which can be a regulation or it can be something that comes out of case law. Is it valid? Is it something that you know, we as the court are going to uphold? And so they go through a 2-step inquiry. And the first step of Chevron asks, is the statute silent or ambiguous on the issue, or is it clear? Chevron step 1. So if the court determines that the statute is already clear, or that there's not any ambiguity, then they will resolve the issue one way or the other right there. Chevron step 2, if the court does determine that there's an ambiguity, they go to step 2, and then they ask, is the agency's interpretation reasonable? And if it's reasonable, then they'll defer to that interpretation. So this has been, again, this has been how administrative law in the United States has worked for 40 years. Now, oh, changing the wrong one. Okay, so an example of Chevron deference, the definition of particular social group. If you've got a case before, you know, and this can come up with the IJ, it can come up with the BIA, it can come up with the circuit courts, and you want to challenge whether something is properly a particular social group, or you want to challenge the BIA's overall definition of particular social group, and the court will look at that. And I've cited a Fifth Circuit case here. Then again, this is just an example of how Chevron applies. And the court will first ask, is the statute ambiguous? Yes, absolutely, the statute's ambiguous. There's nowhere in the Immigration Nationality Act where it defines particular social group. So absolutely. Step two asks whether the interpretation is reasonable or permissible. So again, in this 2012 Fifth Circuit case, the court says, we do not believe that the BIA's interpretation is an impermissible construction of a statute that is decidedly vague and ambiguous. So Chevron step two, the BIA wins. Now keep in mind that may be a different inquiry for every possible iteration of a particular social group that you could come up with. The BIA is going to have a way of interpreting the term, but there are a million different potential particular social groups, and the question of whether it meets that definition is also a question that's subject to review. So this is how Chevron worked. So and I hope that you appreciate this because it took me a full 2 minutes to find this through a Google search. This is the destruction of Chevron. And this is what Justice Gorsuch said in Loper Bright. The Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of the law simply because the statute is ambiguous. Chevron is overruled. So now the courts are supposed to be doing their own assessment. And the reason the court comes to this conclusion is because the Administrative Procedure Act, which is supposed to govern everything, doesn't say anything at all about deferring to the agency on the interpretation of statutes. It says the courts are supposed to interpret statutes. So now the courts are in a position where they may be looking back at precedents or looking at new issues that come up and saying, well, previously we would have said we could go either way on that, and we're gonna go with the agency because that's what Chevron deference told us to do. And now they have the option to say, you know what, we could go either way on that, but we're not going to defer to the agency. We're going to come to our own conclusion, and maybe that conclusion is going to be what the agency has done, or maybe that conclusion is going to be something else. So this presents an opportunity in litigation to have some statutory questions go a different way. Is it a good thing or is it a bad thing? Time will tell. I tend to think of it as a very good thing as a person coming from an appellate background, because this is going to be, 50 years of new litigation fodder for appellate attorneys, because now we can look at every issue that's been decided under Chevron in the last 40 years and say, well, potentially the court should revisit this now that it's the court's obligation to decide in the first instance what the statute means. But it could also be a bad thing because some of the interpretations of the statutes are fairly favorable and they could get worse. So I always am reluctant to tell people to be concerned about making bad law, because you got to represent your client and you got to argue anything that you can argue for your client. But this can potentially go in some negative directions, as we will see. So the rule now that Chevron deference is gone, we go back to what we call Skidmore deference. Skidmore's a 1944 case. It has always been invoked in certain situations. For example, if you've got, an unpublished member panel BIA decision, then the courts will look at that and they'll look at any interpretations there and they'll say, this is a Skidmore deference case. We're not going to give you Chevron deference unless the agency is, this is a precedential decision or something that the agency put a lot of, or put its sort of official imprimatur on. So this has always been there, but now it is sort of the foremost definition of how the courts will interpret, or how the courts will deal with agency interpretations. So Skidmore says, the weight of such a judgment would depend upon the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which give it power to persuade if lacking power to control. So in other words, the courts can do what they want. There are, it's still valuable to know what Skidmore said because the courts, for example, may give a lot of value to seeing that the agency has been inconsistent, because one of the things that Skidmore says is the consistency with earlier and later pronouncements. If the BIA or USCIS is all over the place, that's potentially good fodder for invoking Skidmore deference to your benefit. But that is now the foremost rule. And so I want to go into a couple of cases. As far as I know, there have only been two circuit level precedential cases applying Loper Bright in the immigration context. This first one is kind of fun because I don't know who the lawyer was on this Ninth Circuit case, but it was a good lawyer because this lawyer forced the Ninth Circuit to reckon with Loper Bright 3 different times on 3 different issues in the same case. So issue number 1, do you remember the BIA case, I think it's 2016, Diaz-Lizarraga, where the BIA expanded the definition of theft to encompass joyriding and temporary takings? Well, the argument that the litigant made here is that Diaz-Lizarraga was wrongly decided and the BIA's prior narrower interpretation of theft should prevail, and the court, in reaching its own decision now under Loper Bright, should not defer to the BIA's more recent case, but should take it back to the narrower definition of CIMT theft that prevailed before. So that's a good argument. So let's look and see what decision the Ninth Circuit comes to. They say, prior to Loper Bright, we would under Chevron defer to the BIA's specification of the subset of theft offenses that constitute CIMTs when articulated by the BIA in a published opinion. So that again is what gets us from, in the Chevron days, gets us from Skidmore deference to Chevron deference. Now our task is to evaluate the statute independently under Skidmore, giving due respect but not binding deference to the agency's interpretation. So they're going to interpret this for themselves and ask, what does the Ninth Circuit think about theft? And does modern theft really encompass joyriding or taking something temporarily, this sort of temporary deprivation? And the conclusion they come to, the BIA's decision in Diaz-Lizarraga is thorough and well-reasoned. It is, as we shall explain, also consistent with judicial precedent. So the court looks back at its own precedent and says, you know what? We kind of think of theft the same way the BIA does, so we're going to go with that. So that's how issue 1 gets resolved. Issue 2, this is a goofy one. Apparently, in 1968, the BIA issued a decision saying that if you committed a crime that potentially made you deportable and there was not a pardon available for that crime, then it does not count as a crime for immigration law. This was a thing, apparently, for 20 years I'd never heard of it. Again, this is solid lawyer. And I feel like he had this, or he or she had this one in the vault, just waiting for Chevron to die. Because in 1988, the BIA comes out and says, you know what? We're going to backtrack on that. And it's no longer the case that simply because a pardon is not available for a crime means it doesn't count as a crime for immigration law. So what the lawyer is arguing here is that the BIA's interpretation of this particular waiver provision, which today is in INA 237, and it waives multiple criminal convictions, it waives CIMT, it waives aggravated felony, and it waives high-speed flight. So potential broad applicability, he's or she is, I should look up who the lawyer is because I'm seriously impressed. But the lawyer says the 1988 case should go away and the court should go back to the 1968 doctrine. Cool argument. The court says no, but the court is forced to again look at Loper Bright and say, how would we resolve this issue? So they've got to look at the statute. And the statute says, and again, this is INA 237, that this particular waiver is available when the petitioner, quote, has been granted a full and unconditional pardon by the President of the United States or by the governor of any of the several states. So the question under Chevron would have been, is the provision clear that a conviction must be pardonable in court to count as a crime under INA 237? Now, by a raise of hands, who would say that that statutory language there is clear that a conviction must be pardonable or it's not a crime at all? Not what it says. It says you get the waiver if you've been granted a pardon, but it doesn't say if no waiver is available, you're out of jail free. So step two would have been, is the BIA's 1988 interpretation reasonable? But under Loper Bright, the court has to decide for itself. And not surprisingly, the court says, given the plain words of the statute, we not only agree with the BIA's application of matter of Noel, and that's the 1988 case, to this case and afford its kid more deference, but also independently conclude, based on our own statutory analysis, that the pardon waiver does not require availability of a pardon to find a conviction to be a proper basis for removal. So we see here, looking at the statutory language, looking to see, does it actually say what the interpretation is saying that it says? If not, what do we think? That's Loper Bright. Then, issue number 3. And this is kind of a fun one too. What about the BIA's definition of a single scheme of criminal misconduct? So under INA 237, if it's a single scheme of criminal misconduct, it's only one CIMT. Mr. Lopez went on a crime spree, I think all within one day, and wants to say it's all one CIMT. Sort of out there, but the court again has to say, we can't defer to the BIA's definition of single scheme of criminal misconduct. We have to decide for ourselves what this means. And so the way that they resolve this one is they resort to the rule of orderliness. The rule of orderliness is a circuit court rule that says that a panel cannot overturn a prior panel. So it's a little bit of a cop-out, but this is a rule that all of the circuit courts have, that if you're just before a panel, they have to respect what a previous panel said. The reason this is kind of an odd resolution is because that previous panel relied on Chevron. They deferred to the BIA under Chevron. So then the question is, what does Loper Bright say about retroactivity? What does it say about prior decisions in which the court has deferred? Does the court have to revisit those decisions? And Loper Bright says no, they don't. And it's unclear from like a legal perspective why they wouldn't have to if the courts are required under the APA, which has been the law since, I don't even know, the 50s. If the courts are required to engage in their own interpretations, then why shouldn't they be required to engage in their own interpretations, even if they previously issued decisions under Chevron? Well, probably just to try to lessen the massive administrative burden of having to revisit every single case ever issued for the last 40 years. But Loper Bright does say that it's not retroactive, so that's one thing to have to take into consideration. If it's a new issue going forward, if it's a new interpretation, and we're potentially going to get some new laws here, then Loper Bright applies, and the courts have to use their brains. They have to get up off the couch and actually interpret some statutes. But if it's a prior issue, if it's a prior decision, they kind of get to do what they want. And this is an out for the courts to say, you know what, back in 1984, we could have gone either way. And we're just gonna respect that decision, and we're not gonna revisit it. But usually usually there's only been 2 cases, but what the courts seem to do is they'll say, we defer to the BIA and we independently come to our own conclusion just to make it, make that a solid precedent, I guess. So takeaway, sometimes the newly empowered courts will want to flex their muscles and interpret things anew, but this non-retroactivity may give them an out when they don't want to do that. One solution, of course, here is for appellate litigators, you can't always ask for a rehearing en banc. All the courts en banc can overturn the panels. So if all that's standing in your way is a prior panel decision, you can ask for the court to review it en banc. But I think probably the more practical way to think about it is, I think the best advice I ever got in law school was, if you want a judge to agree with you, you got to give them 2 things. You've got to make them want to give you what you want, and then you have to give them a way to do it. And if the judges do want to give you what you're asking for, Loper Bright is potentially a way to do it. Because if you look back at the decision and you say, oh, this is invoking Chevron, and hopefully it gets to Chevron step 2, and I don't know how many cases actually do this, but hopefully they get to Chevron step 2 and they say, we could go either way, but we're just going to defer. Those are the sorts of decisions that are most vulnerable to attack. Whereas you're going to go back and look at a lot of precedent, like that Fifth Circuit case that I cited, particular social group case, and you look at that case, and sure enough, they rely on Chevron, but then they later will say they say in that case that any particular social group which is circular to the harm is unreasonable always, and so that's not really going to be vulnerable under Loper Bright, because even if they're not even really deferring to the agency, they're already coming up with their own independent conclusion that even if we were to decide this for ourselves, we would still go this way. So not really vulnerable there. But again, in every potential situation, and it is every situation, you're going to want to go back, look at the precedent and say, is Chevron involved here? And if I've got a case where it's going to be a sympathetic case and the judges want to give me, what I got or what I want, is Loper Bright going to be a way to get them there? Here's another one. This is the second one. Sixth Circuit case, Moctezuma-Reyes v. Garland. This is non-LPR cancellation, deals with exceptional and extremely unusual hardship, which is an issue we've seen a lot in the last couple of years, including from Justice Gorsuch in Guerrero-Lasprilla, which was the case that told us that this is reviewable, exceptional and extremely unusual hardship is reviewable in the first place, potentially, in the circuit courts. And why is it reviewable? Well, it's reviewable because it is a mixed question of fact and law, and those get treated as legal questions. And that's going to be important. So what's going on here, and this is where we're going to kind of see some arguments that could potentially have bad consequences depending on how the judges want to deal with them. But we all know about the BIA's list of factors to consider for exceptional, and I won't say the whole thing because I always mess it up, EEUH, exceptional hardship. They talk about family ties, how long has the person been in the United States, health of family members, et cetera. And the litigator here wants to argue that the Montreal factors they should be reviewed under Loper Bright because they are not dealing with, they're not extreme enough. So it's exceptional and extremely unusual hardship, but the case is only talking about family ties and talking about how long you've been in the US. And the attorney says, well, that's just normal stuff. You see where this is not going. So the argument doesn't make a lot of sense because this is not really a bad precedent. This is really kind of, if you think about it, kind of a favorable precedent because it's bringing things into the ambit of exceptional and extremely unusual hardship that may not necessarily, under a different interpretation of that term, may go under there. The BIA could have come out and said, you know what, all these things, those are regular consequences of deportation. So we're only going to consider cancer and going back to a country that's potentially really dangerous. And they could list, only these really exceptional factors, but they don't. And so it's not really a bad precedent. And so the court here could say, yeah, we agree with you, and we're going to issue our own interpretation of EEUH, and we're going to limit that definition to really exceptional stuff. Thankfully, that's not what the court does here, but they do, under Loper Bright, decide, we're going to decide for ourselves now what EEUH means, but thankfully, we think it means exactly what the BIA thinks it means. The BIA had it right. So under Loper Bright, the law is now the same on this issue in the Sixth Circuit as it was before, not worse. So again, this could go either way. Two more interesting issues in this case. The Supreme Court in Wilkinson v. Garland said that the agency gets more deference on mixed questions of law and fact. We don't know why the court said that, but they did. And where my mind goes when I think about mixed questions of law and fact is, of course, to exceptional and extremely unusual hardship. There, I got it. Because that was the issue in Guerrero-Las Prias, and that's sort of where my mind goes to when I think of what is a mixed question of law and fact. But when you think about it, a lot of things are mixed questions of law and fact. If you think about persecution, well, persecution is a legal standard, but in most cases, you're not arguing about the definition of persecution. In your case, you're arguing about whether the facts in the case rise to the level of persecution. That's a mixed question of law and fact. And so if it is really the case that the agencies get more deference when they're interpreting a question like that, then that's something that we really have to keep in mind as we are making Loper Bright arguments. Luckily, in this case, the court decides that this particular statute is not that kind of statute, but they sort of lay out what that kind of statute may look like. So they say, even under Loper Bright, certain kinds of statute might get deference. Those are ones that pair that language with words that expressly empower the agency to exercise judgment. For example, Loper Bright itself cited a provision of the Clean Water Act empowering the EPA to establish pollution limits that in its judgment protect public health. So those words in its judgment might potentially allow the agency to get a little bit more deference than they would get under Skidmore. Is it back to Chevron deference? Who's to say? But it's something to keep in mind. Luckily, the exceptional and extremely unusual hardship statute does not contain that sort of particularly deferential language. And so the court in this case is just going, they're going to make up their own minds on what it means without any particular deference. Let's see. I see two more interesting issues, but I think those are the same issue. Yeah, anyway, okay. All right. I only have one more thing to talk about. So maybe this goes a little shorter. Maybe there'll be a lot of questions. I don't know. This is one that I happened upon just the other day. This was in the blog, just a blog. I haven't seen the decision of a law firm in California that seems to litigate often this sort of issue. So who's ever filed a writ of mandamus? Okay, so a writ of mandamus, the idea is you're going to the federal court and you're saying to the court, either under the Mandamus Act or under the Administrative Procedure Act, there are provisions that allow you to try to get the court to force the government to do its job. And of course, what that requires is that there is some ongoing benefit request that hasn't reached a conclusion. Well, apparently what the State Department has been doing, you know how you've got a consular processing case going and it's either an immigrant visa case or it's a non-immigrant visa case, and you get put in administrative processing. And the way that the process proceeds is you first get a refusal. That's what they call it under 221G. And then they will put you in administrative processing, and then you'll be in administrative processing for however long. And then eventually, hopefully, they'll make some kind of a decision. And this is something that you can file a mandamus on to try to get somebody out of administrative processing. And what the State Department will try to argue sometimes if they fight you, which they don't always fight you, but if they fight you, then they might try to say, well, this is actually no longer a pending request because we refused you and put you in administrative processing. And so they will say there's nothing pending anymore for the court. There's no more duty of the agency for the court to force to comply with. There is a case, it's unpublished, but it's from the DC Circuit Court of Appeals called Karamova. And in this case, the DC Circuit says that when your consular processing case gets refused and then put in admin processing, it can't be the subject of a writ of mandamus because the application has already been denied, and anything the consular post happens to do after that is just them being nice. This is really, really bad law. And it gets ignored and not followed by district courts all over the country. Again, this firm in California keeps a blog of all of the district court decisions saying, yeah, we're not going to follow that. But this was my favorite one. This is from a district court in Minnesota. And in responding to this, Karamova precedent and being asked to follow it by the government, this is what they say. It appears that the Karamova court reached that conclusion based primarily on the provisions of the State Department's Foreign Affairs Manual. Now, you all know the Foreign Affairs Manual, right? It's that list of things that looks like regulations on the internet, but it's not real regulations. And sometimes you find one that you like, and then you go back to try to find it later, and it's not there anymore because they've changed it, right? Foreign Affairs Manual. District judge says, however, it is far from clear whether the Foreign Affairs Manual has any legally binding effect. And Karamova does not illustrate how the interpretation reflected in the manual is consistent with the language of any act of Congress, see Loper Bright. So, Foreign Affairs Manual, gone. not, and of course, Karamova, when they're setting out what the Department of State's procedure is, they say, okay, first, the visa application is submitted, and then you get the refusal, and that's under FAM section whatever, and then it goes in administrative processing, FAM section whatever, and here's the process, and the court is treating that like it's regulatory. And maybe in a Chevron deference situation, you might look at that and say, well, we think that this is, a loose interpretation of whatever statutes allow the State Department to issue visas in the first place. Well, under Loper Bright, there are, the Foreign Affairs Manual isn't interpreting anything. Not only is it not, lawfully enacted under notice and comment, because apparently the State Department can do whatever it wants, but it's not interpreting anything in particular. And so the judge tosses it out and says, this is not binding. And if it's not binding, then it's not a procedure that we have to defer to, even under Chevron. But under Loper Bright, we're going to decide for ourselves, is this is almost verging on what we'd call an ultra vires argument, which is sort of similar to a Chevron argument in that what you're saying is the regulation is apropos of nothing at all. A regulation has to be tied to some statute somehow. Even if the statute is 3 lines long and the regulation is 15 pages, it has to tie in somehow. And clearly the government was unable to convince this judge that the Foreign Affairs Manual tied in to anything. So, so this is a positive outcome of Loper Bright, and a judge actually saying Foreign Affairs Manual, that's nothing, we're not going to abide by that. So I thought that was a lot of fun. That's all I've got.
Well, I've got some questions for you.
Sure.
And then we'll open up the audience. So I guess one opener is, given what you're seeing in the circuit courts right now, do you really think that panel judges are doing their own work on reinterpreting these statutes? I ask mainly because, and I have to confess, I know very little about this, but I was at a panel at the Immigration Law Professors Conference, and some people were very hopeful, I think in the way that you are as well. But I looked up one of the panelists, Michael Kagan, and I guess he jointly filed a motion for reconsideration of the panel opinion in Garland, or in Amici, obviously, he's not a party. And I guess he was saying, and I want to know if you agree with this or not, and I have no opinion, but I guess they were arguing that the panel's approach in that case, determining whether an agency decision is entitled to respect, asked the wrong question under Loper Bright. The right question is what the statute means independent of what the agency said. Evaluating the agency's interpretation should neither be the starting place nor the end of the analysis, nor should the agency's interpretation ever be given dispositive weight, outweighing even the statutory text and structure. So that was their objection to the opinion in Garland. So I want to know what you think of that. And I guess, sorry, I'm a professor.
You say Garland.
Or I'm sorry, this is the Lopez.
Oh, okay, all right.
Yeah, Christian Lopez v. Garland. I guess they filed this on November 22nd. So what do you think? Because you've been looking at this. And then I guess I just worry, especially with immigration, because I'm, I guess, pessimistic, that the laziness of panels will simply lead to sort of a re-ratification of the prior Chevron regime in immigration law.
I think that's extremely likely.
Yeah.
I think that the best way for me to think about it is what I said before, where if you've got yourself a set of facts that is going to get a judge's attention, then this is a tool to be used, but they have every opportunity to just defer to the agency just like they did before. On the question of laziness, I feel like the judges are getting lazier across the board. the district court on the appellate level, where in the past, we would have gotten, even if a case had been denied, we would have gotten a good explanation or a good reason. I had one at the Fifth just this year where I could have come up with 5 or 6 good reasons to deny my argument, and the court didn't come up with any of those. What they came up with didn't really make any sense at all. And so I'm not super optimistic, no, because I think, so many issues have already been decided under Chevron that it's so easy for the court to say, Loper Bright says this isn't retroactive, and so we're just going to go with what we've gone with. But what I saw with Lopez is they're reinforcing that. So they're saying, we have deferred to the agency, not going to defer to the agency, but we like what the agency said. And here, look at our own prior precedent. And look, turns out that we agreed with this all along. That does take some more effort, though. They got to
puts them through their paces.
Yeah. And in so doing, maybe they change their minds. But yeah, there's a lot of opportunity for everything to just stay exactly the same.
I mean, specifically in this Lopez case.
Or get worse.
Right. No, for sure. I mean, it can always get worse. Particularly in this Lopez case, though, I mean, do you think they were doing their own analysis here? Or do you think, is your interpretation like Michael Kagan's, where he thinks, no, they just kind of re-ratified and gave deference, like a new Chevron deference, and called it Skidmore? I just haven't read.
I thought it made. I thought what they said made sense.
Okay.
At least it was, if they were looking to not change their opinion, they found some prior Ninth Circuit cases to back that up. I think the second issue was the pardon waiver issue. The argument didn't make any sense in the first place.
Okay.
And the third issue, the single scheme of criminal misconduct, is a court really likely to say that a day-long crime spree is a single scheme of criminal misconduct? Probably not. So maybe they really, put some thought into it and, came to the conclusion that they would have come to anyway. Or maybe they were being lazy. It's hard to say from that one. It really is.
Good. No, that's much appreciated. So on the question about cancellation of removal and the standard, the extremely unusual hardship standard.
Even you got it wrong.
I know. I have the same I teach that.
It's too many words.
And I never get it
Too many
right,
words that start with E.
as some of my students in the audience can confirm.
I would actually
Exceptional and
practiced
extremely unusual
it. I
hardship.
practiced it this morning.
Oh, that's good. That's good. So on that issue, I mean, when you were talking about that in your presentation, I was just thinking to myself, well, I mean, whatever standard they put up there is not what the court does, right? I mean, when I teach that principle, and I could be wrong on this because you guys in the room know a lot more about it than I do, but it seems like what the courts do is just kind of do a comparative horrors, looking at past precedents, either in the BIA or otherwise. Or, I mean, I'm sure, of course, there are exceptions and where if they really feel for somebody, even if it's, and so it almost, I just wonder, and maybe it just shows again this kind of point about modesty and what this change means for immigration law, because it feels like with cancellation, the fundamental idea is that the judge has a ton of discretion, and whatever standard you're going to have, they're going to do what they want because the standard is effectively standardless. And so I guess I wonder if you have any response to that provocation.
No, I agree with that. I think that the courts are certainly not being forced to reevaluate things that they don't want to reevaluate. Yeah, I think it's always going to be a matter of, convincing them that they're really going to be looking for a way to grant your case. And here is one. It's, that there's just so many opportunities for the court to not change anything. So,
are you seeing any difference between sort of FedSoc, Trump appointee approaches to Loper Bright versus Dem appointee approaches in
Given
the
that-
circuit court so
Given that there's
far.
only the two
There's
cases
just,
that
it's
we've
just
seen,
too soon to see, say.
It's too soon. I'm sure that will play out.
Yeah.
On the other hand,
But even in the panel composition, say in the ones we have, right? We have, what's the panel composition in terms of
I'm not
appointment?
sure.
Okay.
I don't recall whether there were any dissents in either of these two cases on any of the points. I don't remember. I think that is likely to
These are
play
just
out.
things law professors worry about. It's fine.
But the interesting dynamic with the death of Chevron is that it is ultimately sort of has been a conservative push, right? I mean, this has been Justice Gorsuch's thing. And so the question then is, are the conservative justices going to go along with the conservative line of thought that wants to take power away from the agencies, or are they going to want to go along with the conservative line of thought that's anti-immigration? Because they could really go either way. And what it may come down to for some judges is, how could I use this if I take away power from the agency in an immigration case? How might that benefit me in taking, power away from an agency in a different kind of case where I really do care? Because that could empower, conservative justices to sort of emasculate the other agencies, which could be, good for immigration if you play your cards right.
Yeah, I mean, I think that's the best case scenario. I mean, I think the other scenario, the one I worry about, is that in fact, what we'll have is sort of another form of immigration exceptionalism where, every other agency gets sort of blinkered, fair-minded Lopez treatment, and, the EPA never, writes a reg again. And yet here we are, in a reiteration of sort of the exceptional deference that the immigration agency deserves, despite, as you pointed out yourself at the beginning of your talk, we've got laconic kind of short pieces of statute that turn into massive regs that are made by an agency that, doesn't necessarily have the interests of immigrants for sure at heart, or is a faithful steward of congressional intent over the 100 years of immigration law.
I will tell you that I was at the Fifth Circuit, this is maybe 2 or 3 years ago, and it was an extraordinary ability case, which I do a lot of, and an argument that a lot of lawyers have, if you're familiar with this at all, in the EB1A extraordinary ability cases, the government has a policy that's based on a Ninth Circuit case where they will adjudicate whether you meet the criteria, and then they'll do this sort of final merits analysis. And what a lot of lawyers will try to argue, and I saw in an AILA brief at one point, and I kind of incorporated some of that into my argument, was that this policy is really beyond the scope of the 3-line statute that establishes what the extraordinary ability program is. And it was enacted without notice and comment, and it's really quite different. And trying to get that policy struck down, which is not met with any acceptance in any court so far. But I tried to address my argument specifically to one of the judges on my panel, who had written one of the big DACA decisions, in which she specified that the DACA policy was illegal for not having complied with notice and comment. And I tried to address my comments to her and say, look, this EB1A policy is exactly the same as the DACA policy you struck down. And she never said a word. She wasn't listening at all. So that fell flat. But I was trying to appeal to her, anti-immigrant sense. It didn't work.
The power to decide is different than the power to give or the necessity of giving reasons. Thank you so much. Why don't we open up for questions from the audience in the back and in the front? All right. So just please wait for the mics. Speak into the mics, sir.
This question is for Attorney Green. The last slide in the case that you mentioned, AWOL v. U.S. Department of State, do you have input on whether or not the decision to put the case into 221G for administrative processing, is that subject to mandamus? Because it seems it's a very interesting analysis.
Most of the courts seem to say yes.
Okay.
But of course, I'm getting this from a blog that only lists positive outcomes, so maybe not. But there are a lot of unpublished cases out there in the district courts allowing a mandamus to go forward on administrative processing. And I have done mandamus on administrative processing, and those have been cases where the government hasn't fought us. And so I've never, had
Never
the
encountered
opportunity
that.
to actually argue that, and that's a lot of times what happens when you file a mandamus anyway. So we've got this DC Circuit Court of Appeals case, but it's not published, and the district courts don't seem to like it very much.
Thank you.
Wonder why.
And I'm happy to send you what I was looking at there if you need some backup on that. It was
Hello.
something that somebody posted on the AILA Federal Lit listserv. Anyway.
So
next
going back
question.
to this reiteration of exceptional deference to BIA decisions or judicial precedent, and we touched on this with mixed questions of law and fact. Is that, well, can you just explain that again? Because I wasn't really sure how that would be different, how they would defer more than questions of pure law.
Yeah, I don't think we know until a court comes out and says, let me go back to my slide there. Oh, is the slides gone? I got them here.
We have our tech guys.
I would say that mixed questions of law and fact, there's distinguishing factors that they could go into with a Skidmore.
So I don't really know. Like I said, I don't think anybody understands why the Supreme Court said that. If a mixed question of law and fact is to be treated as a question of law, then you would think that the deference to any legal interpretation would be the same. So why the court said that and what will happen with it and whether it will be sort of ignored or whether there will be some kind of distinction between pure questions of law and what appears to me to be the majority of these sorts of questions that come up, which is just like the persecution issue. Is all this stuff that happened to me, does that qualify as persecution? Why they would be treated differently, I don't know. I don't think they should, but I don't know. I don't know the answer to that. And I don't know like I said, I don't know what the level of deference would be either if it goes back to Chevron. I try to put myself in the position of a court looking at a question like that. Let's just say the exceptional and extremely unusual hardship question. Number one, I might want to just defer and not make a bunch of exceptional and, did I screw it up? Exceptional and extremely unusual hardship analyses myself. So, that might just be laziness that plays in there. Or I might look at that and I might say that this is what the BIA and the immigration courts do on a daily basis. But again, how that gets you out of interpreting what a statute means, I don't know, because the question is, what is persecution? Is this thing that happened to you persecution? That's still a legal question, so I don't know.
Thank you.
I mean, I suppose one option, right, is that they could decide, and I don't know how plausible you think this is, but they could decide, well, we're just going to review and make sure you dotted your I's and crossed it. Like it looks, which, sometimes circuit courts do on review of immigration decision, which is like, did you dot your I's and mind your P's and Q's?
Did you mention it?
Right. And so does it look like legal analysis? Is it an A exam or a C exam? Right. And so if it looks like legal analysis, then we're not gonna, but we won't disturb the factual determination. I mean, I can imagine that as an ultimate outcome.
Yeah, yeah. What we see in the district courts, which is of course a whole different standard of review, it's substantial evidence, is any of those cases that prevail, it's usually because the agency failed to mention something. And so if there's a possibility that they overlooked evidence entirely, that's often where litigants will prevail at the district court. It's not in convincing the judge that the facts in this case really are so outrageous that no rational adjudicator would have gone the other way. It's, can you point to something that the agency failed to mention at all? Is there something missing from their analysis? That's where people tend to win.
And I mean, we see that with criminal appeals, right, too, right? It's always like, oh, did you miss something? Was evidence not admitted, right? Like, was there a missing piece? Yeah,
right.
Makes a lot of sense. Other questions from the audience? Come on, admin law nerds. You know you love it. It's a long day. All right, should we call it? Oh, okay. Oh, no, we've got some questions. Sorry, do we have one in the back or do we go to Professor Cabot?
How, if at all, do you think this will influence the BIA precedents going forward?
Well, probably not at all. Unless we're to talk about Brand X, which I had a slide on, but I decided not to talk about at all. Because what we're talking about here is the agency interpretation and how that is looked at by either a federal district judge or an appellate judge. Obviously, the BIA is the agency. So the only possible real impact I think this could have at the BIA level without being overturned on some point and having to go in a different direction would be if there were a Brand X situation. Brand X is a case that followed on Chevron. Brand X is probably also now dead. In fact, I think it was on my slide that I decided not to go to, where Justice Gorsuch basically says that Brand X is dead. What Brand X did is it said that essentially the agency can overrule a circuit court precedent if it's on a statute which is in the agency's expertise and the agency thinks it's being reasonable, right? So it's one logical step beyond Chevron, which allows the agency to sort of proactively be reasonable, presuming that on review the circuit court would just agree with them because they've said they were reasonable. So the reason I decided not to bring up Brand X is because I couldn't find any real BIA Brand X decisions. I had a whole list to start with, and I went through them, and in every case that I looked at, and I didn't look at them all of them, but in every case that I looked at, when the BIA comes up against a circuit court precedent that it wants to disagree with, it only disagrees with it in the other circuits. So in the particular circuit, like if the BIA disagrees with an interpretation of the Fifth, it will follow its own rule in every other circuit, but in the Fifth Circuit, in cases arising in the Fifth Circuit, it will follow the Fifth Circuit rule. So I didn't see any actual Brand X cases. So if that holds true, across all potential precedents, it seems like that the BIA wouldn't have to make any sort of preemptive Brand X determinations where they said, you know what, we don't think, this is kind of funny, we don't think the circuit court is going to think this is reasonable anymore. I guess why would they do that anyway? But because they don't actually invoke Brand X and actually overrule the circuit that they're in, I don't think the BIA is going to be doing anything with Loper Bright. They might be persuaded by an argument that your decision is really crazy and the circuit court's not going to like it, and now they have a broader scope of review, so maybe you avoid the embarrassment and change your mind now. But that's kind of always how it's been.